Audio check. Good morning, everybody. My name is Dave Arconti, and I'm joined today by my colleagues, Commissioner Beecher, Commissioner Cheeseman. This morning, we have oral argument in docket number 250403, joint application of Aquarion Water Authority, South Central Connecticut Regional Water Authority, and Eversource Energy for approval of a change of control. So I will take appearances, address any administrative matters, and then proceed with the argument. So any attorney representing a party or intervener who intends to participate in oral arguments this morning, please approach the microphone, state your name and the party on behalf of whom you'll be presenting argument. Thanks.
Good morning, Commissioners. Andrew Minikowski, Legal Director for the Office of Consumer Counsel. I'm joined today by Consumer Counsel Claire Coleman, Attorney Allison McCorney, and Rich Sobolewski, our Director of Technical Analysis. Consumer Counsel Coleman will be delivering our argument this morning. Thank you.
Good morning, Commissioners. Caroline McCormick, Assistant Attorney General on behalf of the state of Connecticut. I'm joined here by Attorney General William Tong and Assistant Attorney General John Wright. Attorney General Tong will be delivering our argument today.
Thank you.
Good morning, David Ball on behalf of the towns of Fairfield, New Canaan, Ridgefield, and Westport. Thank you.
Good morning, Attorney McLeod on behalf of the Connecticut Metropolitan Council of Governments and the Western Connecticut Council of Governments. Thank you.
Good morning, Dan Canavan from Harris Beach, Merthyr, on behalf of the South Central Connecticut Regional Water Authority and the Aquarion Water Authority. Good morning.
Good morning, Commissioners. Vincent Pace, Assistant General Counsel for Eversource Energy on behalf of the joint applicant, Eversource Energy.
Okay, that's it. Okay. So first, before I ask if there are any administrative matters for y'all, I have a couple. Per regulations, the applicants are entitled to open and close. And here we have a joint applicant. So I would ask the applicants to decide who's gonna do the opening and close, whether it's Eversource or RWA, AWA. And then also, normally I just want to preface for all the attorneys doing their argument that expect commissioners to jump in as questions kind of pop up. Don't just anticipate we're going to wait until the end of a presentation to ask questions. And with that being said, are there any administrative matters that the parties or interveners would like to raise at this time? Attorney Pace?
I did have one clarifying question, and that is on process for today. I know the authorities' normal practice would be for those parties who requested oral argument, they would go first and the company would have a chance to respond. And we asked that the authority, just to clarify, will follow that practice whereby those entities, such as the Consumer Counsel, the Attorney General's office, and the towns who requested oral argument, we'd request that they proceed first and the company could then respond to the arguments they make, since we did not request oral argument. But we reserve the right to participate for those who elected to do so.
So you would prefer that those parties who requested oral arguments go, and then following their oral arguments, you as the applicants have the ability to respond contemporaneously. Is that correct?
Correct, Commissioner Cheeseman. We think that would be the most efficient approach. It's also consistent with authority practice and other proceedings. Thank you.
So you have the option of going first, so you're kind of waiving that?
Correct. And we are fine responding to the entities who requested oral argument. They can proceed first.
Okay.
Thank you very much, Vice Chairman.
Any response? Oh, Attorney McLeod?
Thank you, Vice Chairman. It seems like one question always leads to another question. So my question and response to that is, if they are responding to our argument, what does that do to the usual course of rebuttal?
Yeah, it's so you beat me
Is
to
that
it.
it?
No. You beat me to the other kind of announcement I wanted to make. So we will keep in practice with, first round. And then we'll probably take a 10 to 20-minute break and then come back for the second round, which is the rebuttal round. That being said, per our regs, the applicants do have the option of get to close out their presentation, but there will be that rebuttal round after the break. Does that answer your question?
Yes, thank you.
Okay, thanks. Okay, so let's go with OCC, Towns, the COGS, the Attorney General's Office, RWA, Eversource as the order for the first round. Okay? All right. The show is yours.
Good morning, commissioners. I just want to acknowledge at the outset that I don't relish being here before you today, urging you to reconsider a decision that I know you personally and your staff has spent extensive amount of time on and now has done so twice. But nonetheless, we are here to urge you to reverse the proposed final decision. We understand how challenging this case has been. You are charged with navigating both an imperfect public act and an imperfect remand decision from the Superior Court. So while we understand the inclination to read the Superior Court's remand decision broadly in a manner that allows the authority to say, point to the legislature and say, they've already made these decisions, the authority can't do anything about, we urge you that the remand decision from the Superior Court does not require this outcome. And we are here today hoping that you will not relinquish your authority, your important expertise, and technical, independent, critical judgment to fully evaluate all aspects of the transaction and whether it's in the public interest. There is no support in the record for the new conclusion upon remand in the authority's PDFD that, quote, the General Assembly has indicated a preference for a public or quasi-public option. The General Assembly expressed no such preference in enacting Public Act 24-1. While we don't need to consider legislative history since the statute is clear on its face, the recorded legislative debate makes even more clear that the General Assembly was intended.
Excuse me, Consumer Counsel, I'm taking the Vice Chairman at his word. So you indicated the legislature expressed no preference. I find it difficult to reconcile that with the express intent of the legislation, which was to create this quasi-public authority modeled on the RWA model.
Thank you for the opportunity to clarify that. The enabling statute does not state that the purpose of it was to express a preference for the public model. In fact, if you look at legislative debate, there's some comments from Senator Fanfara on a floor speech, June 26, 2024, where he said, quote, I think it's clear to everyone this merely provides South Central Water Authority to bid. It's permissive. And then he later says, quote, it must whatever, the transcript's a little imperfect, so bear with me. If there ends up being a bid that they prevail on, that it must be approved by the regulatory authority, PURA. That's significant. That's significant. It will be fully vetted by the staff over there. So in essence, what the legislative history shows is that it was enabling RWA to be in a position to bid, because without that enabling legislation, it wouldn't be allowed to bid.
And the enabling legislation specifically outlined the structure, which is based on the quasi-public ownership. And I'll let you continue. We're obviously, this is the whole point of listening to your argument today. Thank you. Thank you, Vice Chair.
Absolutely. And it does set out a framework such that if PURA is to approve the acquisition, that it would thereby be set forth. But we view that framework as sort of a floor, not a ceiling. And we can get into some of those specifics. If the legislature didn't want PURA to have a role, it would have been reflected in the statute. And if you look to the original RWA enabling statute, Public Act 77-98, where RWA was established from an investor-owned utility, New Haven Water Company, it did not specifically require DPUC approval. So I think you can read from that the addition of the PURA approval at Public Act 24-1 as an explicit preference that PURA is going to evaluate whether the transaction as a whole, including the framework established in terms of the structure that would be implemented upon acquisition, is in the public interest. So we urge the authority to still embrace its role with regard to the public interest standard. And we disagree with PURA's interpretation of the Superior Court decision to say that it has very limited authority, both with respect to Section 1647 and 1622. The Superior Court actually ruled that PURA retains full discretion and must conduct a separate public interest analysis. And we think that this public interest analysis is really the opportunity PURA still has to evaluate the transaction as a whole and reject it based on it not being in the public interest. And I think we can use the authority's approach to the Office of Consumer Advocate as illustrative of why taking such a broad read of the Superior Court decision does not make sense. So in the prior final decision, PURA determined the structure and staffing resources of the OCA was insufficient and failed to satisfy 1647. And then in the end sort of said, based on all of this analysis, this transaction was not in the public interest. The Superior Court determined this was in PURA's discretion and left that finding undisturbed. Yet, on the same record, PURA now reverses itself, not because it thinks the OCA structure will benefit customers, but because it's reading the Superior Court remand to say it must find the structure is in the public interest because it was part of the framework included in the legislation. We disagree with that. To the contrary, the court found that PURA should balance various considerations. It said, quote, "The court concludes that balancing the various statutory and policy considerations that may go into determining whether the plaintiffs have met their burden to show that approval of the application is, quote, in the public interest, is inherently a decision that should be made in the first instance by the responsible administrative agency, here, PURA. PURA should amend the proposed final decision to reflect this clear instruction from the Superior Court." I think at its core, our office's fundamental disagreement is with the conclusion that the applicants have met their burden, that the transaction is in the public interest, and the conclusion that, quote, "the application cannot be denied." It can be denied. And the exorbitant purchase price alone makes the transaction a sufficient basis for that because it is, based on the record, a bad deal for Aquarion customers. Regardless of the label you put on it, Aquarion customers will be forced to pay the interest and principal on the purchase price. Evidence, including attachment 2 of late file exhibit 2, shows that debt payments will be required through 2026. That's 40 years from now. Stretching out the recovery of the cost of the acquisition to 40 or even 60 years might appear to save money today, but it has future generations paying the cost of the acquisition and the above book value premiums. So while OCC does agree with the authority that it can't alter the transaction price, it can determine that the transaction price makes the deal not in the public interest. This financial impact on Aquarion customers in and of itself is enough for the authority to deny the application going forward. And it's important to realize the General Assembly did not know the cost of the transaction when it authorized the enabling language. So this is a critical component, right? And as the Superior Court acknowledged, PURA, quote, PURA is expressly required to consider, inter alia, the public interest in deciding whether to approve the application, end quote. This includes the financial impacts. OCC's initial brief submitted in August of 2025 addressed in detail the flaws of the RWA model, which we proved are the basis of assumptions, speculations, and hypotheticals. And the authority even recognized in its decision that there is no other avenue than for customers to pay for the acquisition premium. RWA, we recognize, has consistently said it's raising rates not due to this debt, but due to capital infrastructure needs. Yet it's also admitted in evidence, you can see it in late file exhibit 2, that, quote, as more and more of the acquisition debt is paid off, there is an increasing amount of internal funds to pay for capital expenditures, end quote. To us, that is a concession. In other words, the acquisition debt is still creating upward rate pressure. RWA has also conceded that its modeling is subject to change, and, quote, the debt structure at issuance will be dependent on market conditions, end quote. So in essence, there's no guarantee as to what customers will be paying. Since AWA will not be regulated, they can alter this debt financing, they can change rates, they can do what they deem is in the entity's best interest. They can try to recover these costs however they please. So essentially, while the PFD acknowledges many of the concerns OCC laid out, we believe it then inaccurately concluded that the extreme acquisition premium is counterbalanced by unspecified savings that may someday materialize under a public ownership model. Connecticut case law is clear. Speculation and assumptions cannot form the basis of an administrative decision. PURA's approval hinges on too many unproven hypotheticals with flawed underlying assumptions that may or may not someday come true. OCC respectfully submits that this would not be upheld in court. The authority has recognized, quote, that there is a strong public interest in ensuring that changing control of a regulated utility does not result in unjust or unreasonable rates, end quote. OCC urges the authority to revisit the record in this proceeding, which falls short of the applicants meeting their burden that the costs imposed on customers are in the public interest. In conclusion, to put it frankly, PURA had it right the first time when it denied this transaction, and the court's decision does not require the new conclusion PURA has reached in the proposed final decision. The transaction is inconsistent with the public interest. It subjects Aquarion customers to decades of debt payments, and as the authority recognizes, leaves many unknowns in terms of quality of service, consumer representation, and broader financial and infrastructure impacts. I urge the authority to reconsider its proposed final decision and preserve the original denial of the application. If the authority has questions, I'd be happy to answer them. And if not, I thank you for your time, for listening, and for your consideration of both our arguments today and all of the briefing that my team and I have worked on throughout this proceeding. I also want to acknowledge my team here today who has worked incredibly hard over the last 2 years, particularly digging into all those financial models and really guiding our office's position in this case. So thank you.
Thank you, Counsel Coleman. I just have a couple things. I noticed in your remand brief, you cite the FERC's guidance for assessing mergers and acquisitions, and with particular emphasis on whether they might be in the public interest. So I'm wondering if you'd like to comment on that, and I'd also like to ask if there's anything comparable in Connecticut law that authorizes PURA to apply those standards.
Thank you for the question, Commissioner. I did notice that the proposed final decision did not rely on those FERC decisions we cited, so I appreciate the opportunity to emphasize that we do think that is important, instructive guidance. It is not binding on the authority, but considering it is in the context, a very similar context as the authority has here today, we think it should be instructive, particularly as it allows for the evaluation of financial and rate impacts. And as far as other cases, I'm going to defer to my esteemed legal director if he may have something to supplement, but we would also be happy to follow up with that question.
Good morning, Andrew Minikowski for the Office of Consumer Counsel. Commissioner Beecher, thank you for that question because it raises a good point. The public interest, what is that? Our statutes don't tell us. Title 16 is silent on it. So when we put together OCC's brief in response to the authority's briefing order, we went out and we tried to find comparable situations. And obviously FERC has struggled with this issue in the past as well. And they have a series of ways they've approached this over the years. We went all the way back and looked ahead. The Federal Power Commission used to analyze it under, I think it was a 6-part test. And then FERC revised that in the 90s. But at the end of the day, as Consumer Counsel Coleman said, none of that is binding. It's instructive, however, given the fact that Title 16 is silent. And I believe in our briefing, we cited 2 cases out of the DC Circuit from 2022 and 2024 that both looked at the rate impact in terms of mergers. And they said, have the applicants in a merger situation taken steps to minimize the impact on consumer rates? And that was a valid part of the public interest analysis that FERC employed in those cases. The DC Circuit upheld that way of looking at it. So obviously this isn't FERC, but given the fact that FERC has many shared functions and a similar regulatory role to the authority, we think that that guidance is appropriate in this context to figure out what does the public interest mean in terms of PURA. And we looked there at how other commissions have dealt with this issue, because the public interest, everyone loves that phrase, but no one ever says what it means. Black's Law Dictionary, an actual dictionary, neither of those are terribly, illustrative in terms of what someone is supposed to do with that phrase. But the way courts have approached it is when an administrative agency is charged with determining what the public interest is, what the courts have said, and they've said this in Connecticut as well, is look at the overall statutory scheme that the agency is charged with implementing. So in this case, Title 16 and parts of Title 16A. And what are the goals of that statutory scheme? And how does that inform what the public interest should be to the commission? And in this case, we would submit the rate impact as paramount, because what is the core function of PURA? It's the regulation of rates. And that's in 1619E, the general, in 1619, the general rate making statutes of the authority's powers. And so we would submit that looking at the rate impacts of this transaction really should form the core locus of the authority's inquiry as to whether this proposed transaction satisfies the public interest, which of course we would submit it does not, given the gargantuan impact of that acquisition premium on ratepayers.
Thank you for that. And just so you know, it's a topic I've struggled with for a couple of decades now. So I certainly understand where you're coming from on that. Counsel Coleman, you also mentioned since there's no regulation. And is this something you've thought about? Have you thought about whether there is a sort of regulatory void when it comes to, in particular, this type of change of control, or even more generally, for multi-local jurisdictional water utilities or public authorities or anything like that? Have you ventured into that space at all? Do you have any comment?
Absolutely. Thank you. We've been careful in this proceeding not to have our opposition to this transaction be sort of an indictment of the public model. There are plenty of examples of successful public water utilities, across the country. The model is, however, different, and the level of oversight and the level of consumer representation is reduced. So when you combine that with the significant unknowns in the financial impacts, we do have a concern. And I think the reason we're also concerned with PURA's reliance on the offer of compromise is because of that lack of oversight. It is not a settlement agreement that has binding contractual provisions. It's simply representations by the attorneys who are representing the parties. And PURA has no ability to enforce that, even if it's stating that it's going to incorporate, by reference, these commitments.
Isn't that something, sorry, I don't want to interrupt your train of thought, but isn't that something we struggle with even with settlement agreements? Once jurisdiction is gone, is the remedy to go to the courts?
We believe there's a distinction with settlement agreements that have two parties that are in agreement, and that is a contractual commitment. And if we were to sign a settlement agreement with RWA and AWA, we'd have an enforceable action to go to Superior Court. But in this case, we would not have that. So that's the distinction.
Thank you. That's all from
I have a couple questions kind of picking up on that line. So it's my understanding that in Maine, right, their PUC still has oversight over their nonprofit water utilities, right? So they still oversee rates, service quality, terms of service, tariffs, rule changes, infrastructure, surcharges, et cetera. So I guess a question, when this legislation was back in the summer of 2024, did your office approach the legislature and have any discussions around this oversight gap that was in the drafts at the time?
Unfortunately, we did not have the opportunity to, other than some last minute attempts as the bill was being brought out on the floor, to engage in the structure of the proposed RWA-AWA model. We have pointed out since the passage of 24-1 that other states like Maine do retain some oversight, and we've suggested that that would be a strong model here, potentially with a transition period even, given the number of towns implicated in this huge transaction. It would be a great exploratory model for allowing PURA, the state regulator, to ensure that customers are still protected through this transaction. So long way of saying it was not part of the I don't believe it was part of the legislative discussion when the statute was passed, but certainly has been something we've discussed with multiple parties since then.
So the legislature had a special session in November. Did you petition the legislature to include this subject matter in that call? And the legislature also enacted emergency certified legislation weeks ago. Did you petition either the administration or the legislatures then to include anything of this nature in the emergency certified bill?
I'd say I've fielded some inquiries and talked with those who are interested in figuring out how to address the challenges for the authority, but I did not petition the legislature, no.
Commissioner Cheese?
Just going back, you included a quote from Senator Fanfara. One, obviously, individual legislators had their particular ideas, but if the legislator had not wanted to be prescriptive about the model, surely they just could have said, we're giving RWA the ability to bid and end it there.
I agree that would have been the preferred method.
But they were incredibly prescriptive about going to this model. So I suppose getting back to your point, they weren't really saying they liked this model. It was just, but it seems to me from the reading of the legislature, they were very prescriptive about this model moving forward.
My read of it is the statute mimics the current structure and framework of the RWA, and that, of course, I don't want to speculate as to the intentions of duplicating that here, but the framework, again, in our view, is a framework, and it does not prohibit the authority from evaluating that framework and saying, if it were implemented in the context of this specific transaction, is that in the public interest? And that's where, while the statute may be prescriptive on how the voting happens, the board structure, various provisions of statute, I would concede the authority is stuck with. It does not eliminate the authority's ability to independently evaluate whether that structure is a good deal for the public. And we respectfully submit that the evidence in the record does not show overall with any certainty that this is going to be in the public interest.
I'm going to have this question for the towns later, but RWA has been in existence for what, 40 years, 50 years?
1978 statute, I
So
believe. I
we're
said.
looking at almost 50 years. Were conversations had with the town's existing customers to see how they felt about having that kind of authority deliver that incredibly vital thing, safe, potable water?
I agree. That's a really important question. I'm going to let the applicants and the town speak to that directly.
But Office of Consumer Counsel obviously had no contact.
No, it was not floated before.
All right,
The idea was not floated to us before.
all right. Thank you.
And
Thank
then-
you, Vice Chair.
Thank you. I guess this question is kind of, may ask it of everybody too, because there's a lot of aspects of this that we're all struggling with. You know, and I hear, and I empathize with the arguments on intent, but what I'm having trouble with, and maybe I can ask all the brilliant lawyers that will be appearing before us today, their interpretation is Section 62 of 24-1 states that the enabling legislation shall be controlling wherever it conflicts with the provisions of any other general statute, special act, or any other municipal ordinance. Can you just kind of reconcile that section with?
Sure, I'll
the
give it a
arguments?
shot without having it before me. My view of that is it's saying it can't conflict with other municipal ordinances, but it does not speak to
Or any of the general statutes?
right. So it could not conflict. In fact, you could argue that it supports the argument that the authority exercise its statutory obligation to ensure rates are just and reasonable, and considering that this transaction does not result in just and reasonable rates would be a reason to demonstrate a conflict there with that statute.
And actually, I think I'm okay. Okay.
Thank you. We greatly appreciate your time and consideration of our views.
I think I put you guys down a second. I'm trying to find the page in my notes where I wrote the order. Yeah, Towns. Thanks. Attorney Ball.
Thank you. David Ball from Conan Wolf. And as I indicated, I'm representing the intervener towns. And let me, there are multiple points that I'd like to make. Thank you for the opportunity. The fundamental disconnect between the proposed final decision and what I think the proper decision should be is in the interpretation of Section 34 of the enabling legislation, okay? So if I look at page 19 of the proposed final decision, there is the introduction of this entire decision is based on what I would submit to you is a false premise. It states Public Act 24-1 affirms a strong public interest in having public or quasi-public ownership or control of utilities, and the proposed transfer will advance this interest, and then cite Section 34. And respectfully, that's not true. Section 34 establishes 2 points that no one can disagree with, okay? It provides that the providing of water and wastewater disposal and advancing water conservation is a public purpose. No question. Whether the winning bidder is AWA at RWA or the winning bidder is an investor-owned utility, this is a public purpose. No one can disagree with that. It also provides that if PURA approves this, AWA would be performing an essential government function in the exercise of its powers. Again, who could disagree with that? There is no question that providing safe and reliable water service is an essential government function. That is very, very different than leaping to a conclusion that therefore the legislature was imposing on Pura a mandate to approve this transaction. And it is very, very different than leaping to the conclusion that the legislature made a finding that public or quasi-public ownership of Aquarion is in the public interest. Judge Budzik certainly didn't go that far. And as OCC counsel correctly identified, the purpose of the enabling legislation was twofold. One, it allowed RWA to bid. It's clear, the legislative history is clear. And two, it gave you, Pura, the unfettered power to review the proposed transaction under the change of control statutes without limitation. That means it's your job, irrespective of the proposed structure, to determine whether this transaction, the impact on customers, the extraordinary rate increases that are going to follow is in the public interest. That is solely reserved for your review. If the legislature had already determined that the sale to a public or quasi-public entity was in the public interest, there would have been no purpose to having bidding. There would have been no need for any investor-owned utility to bid, because after all, the legislature would have already concluded that this sale has to go forward. And while we're at it, if that was truly the determination of the legislature, if there was some sort of legislative mandate, your review would have been completely unnecessary. There'd be no purpose. If this is a preference for a public or quasi-public option, it would have said so. That is just not the way the enabling legislation is written. All it does is say as follows: in the event that AWA is the successful bidder, this is what the future governance structure will look like. This is what the future construct will be. Now, Pura, before we get to that point, it is your job to evaluate under the change of control statutes under 1647 and under 1622, whether there's managerial suitability, whether this is in the public interest. And respectfully, this entire premise of this decision, that there has been a indicated preference for a public or quasi-public option, is not what the statute says. And I would suggest to you that if this decision continues to be based on that misreading of the statute, this matter is very likely to be reversed and remanded again to Pura. I simply believe that's a misreading of the law. And before I go, I can see some desire for questions. So before I go to my
Yes,
second.
and if I misunderstood what you were saying, it basically, you said the legislature could tell an investor-owned utility to whom they could sell this? Is that what you're saying?
What I'm saying is that the reading of the enabling legislation, that there has been a dictate that this must go to a public or quasi-public option, is not what it says. In other words, it is true that the legislation gave AWA and RWA the right to bid. It did not foreclose the ability for investor-owned companies to bid. If there had been a predetermined mandate that this had to go to a public or quasi-public entity, it would have said that. It does not say that.
All right. Not sure I'm buying that argument, but thank you.
It would have, I understand,
Yeah.
but very explicitly, it would have said, there is no need for bidding. If there was truly a preference for a public or quasi-public option, there'd be no purpose to your review. It would have been mandated. This would have gone through. There wouldn't have been bidding by other companies. It would have simply been approved by the legislature. That isn't what this says. The language is quite limited as to what its findings are. And the legislative determinations, as I said before, are limited. There are two of them. One is that this is a public purpose, no dispute. The second is this is an essential government purpose, no dispute. Nowhere does it say that this is a preference. Nowhere does it say that this is mandated. And I think that's the disconnect. And that's why this is a flawed draft decision.
The entire outline of that special act and that section of the special act outlines this model. And I was there as Judge Budzik heard the argument, and there was much discussion about public interest. And indeed, that the legislature, as the duly democratically elected representatives of the people living throughout the state, are in many ways the final arbiter of what's in the public interest, even though it is in PURA's authority. But that was a long discussion, and I believe it may have been with some of the representatives of the towns.
And Judge Budzik was really clear that the public interest is something for you to determine. He is abundantly clear. There is no ambiguity in his decision. He did not determine that the public interest has been established to favor a quasi public option. That's simply not what his ruling is. That aspect of his decision we agree with completely. It's remanded to you with your full regulatory authority.
All right, thank you.
Okay. I will just piggyback a bit on, well, let me go to a second issue. There is an issue as to whether or not the applicants have met their burden of establishing that this transaction promotes local control. And in the original decision, which as OCC counsel stated, we think you got right, there were multiple grounds for your conclusion that the transaction would not promote multiple control. Now, part of the decision-making in November was that the structure of the AWA Representative Policy Board and the Expanded Authority Board did not promote local control. Judge Budzik said, time out, you've gone too far, that's already been determined. But that wasn't the only basis for your conclusion in November that this transaction does not promote local control. On page 26 of your November decision, you also stated, and lack of local support for the proposed transaction substantially impairs meaningful local representation and control. That lack of support from virtually every single municipality that has participated in this transaction in the Aquarion region is clearly something for you to consider. That's not a legislative mandate. That is wide open for you to consider as to whether or not you should deny this application.
Attorney Ball?
Yep.
Where would PURA look to in statute to take public opposition into account, and by what method?
Yeah, I mean, I think that's a good question. Under section 16-11, a transaction has to promote local control. So that's the fundamental statutory basis for this requirement.
That might be the question, but what is the means by which a regulatory authority takes into consideration that
Understood.
Concerns about that or any other issue?
And I believe the short answer to that is on that issue, on the issue of local control, it's broadly interpreted. I think you have simply the discretion to consider those factors that you believe are relevant. I don't believe it is abundantly defined. So when the evidence at the hearing was that there was no local support for this, not just because of the governance structure, and I want to be clear about this. I understand the concern that the governance structure has been predetermined, but towns have every right to say, wait a minute, we are looking at massive rate increases, a reduction in tax revenue, the elimination of OCC and replacement.
Can I
with-
stop you just right there? On
Yep.
the reduction of tax revenue, right? Like the legislature is very, very astute to pilot. And they created this to be like, they created the ability to shift to this structure to
Right.
begin with.
Right.
So can you just like reconcile that for me? Because
Okay.
I have to assume that they knew that property taxes,
Right.
et cetera, would be collected very differently versus a continuation of an investor-owned model.
Right, and understood. And our view is that, first of all, there is no limitation on your ability to consider the governance structure. I understand Judge Budzik's ruling, and it's on appeal, and we believe it'll be reversed. But as we stand here today, even if you don't consider the governance structure, the point that I was making was that this is relevant to why there is such vocal opposition and why local control should be considered in that context.
And I'm going to jump in here, Attorney Ball, and I will pose the same question that I posed to the Office of Consumer Counsel. Obviously, the RWA model on which this is modeled has been in existence for close to 50 years. Did the local mayors, first selectmen of the new AWA authority have conversations with their fellow mayors and first selectmen in the RWA districts to say, what's your experience with pilot? What's your residents' experience with water quality, with dealing with, did those conversations take place? Because we're talking about, we're looking at speculative things in the future. We're looking at a company, an authority that has a close to 50-year track record. It would seem to me, and I believe my good friend Laura Hoydick was one of those who was objecting and she was chair of CCM. Did you reach out to your fellow municipal leaders to say, hey, we were very upset about this. Share your experience with this model.
Okay, so first of all, I have no way of knowing the answer to that question. And the reason is because it simply wasn't part of the record. And I'm evaluating this based on the record. I don't know whether those conversations have happened, but if I could answer your question, any of the first selectmen or mayors in the Aquarion region could do a simple evaluation of the historical rates in the RWA region. Maybe RWA is run great, maybe they are, but the rates have been consistently higher, dramatically higher. And that is what makes this fundamentally a non-starter. Not to mention, if you look at the elimination of the tax revenue, even if the future model, if this were to be approved by you, included pilot, by no means does that mean the town support that, because they don't. It is one of the reasons we believe this is not in the public interest. We can look at the rate history. We can look at the consumer advocacy history and have our own concerns. And frankly, all I can do is represent my clients and the positions that they have instructed me to move forward with. The elimination of PURA as a regulatory agency on rates is something that is potentially devastating and terrifying to the towns, which is exactly why they are opposed to the transaction, as you can understand.
The towns petitioned the legislature to include this subject matter in the call for the November special session and/or include an emergency certified bill 3 weeks ago.
Yeah. So my understanding, you saw the letter from I think 3 dozen or so legislators stating just that give us time. There is still a legislative discussion as to whether clarification of the intent of this legislation is needed. So that's an ongoing process right now as we sit here. And yes, of course, the towns were involved in that. So right now, our hope is that what we think is a clear piece of legislation, the enabling legislation, to the extent we disagree with Judge Budzik ruling, we certainly hope and expect the legislature will clarify that the intent was not to tie your hands and disallow your review of the governance structure.
Attorney Ball, thank you. So on this issue of rates, all right, so Aquarion is a standalone company, as are investor-owned utilities. They only turn to ratepayers to support their cost of service. AWWA will be a standalone entity. Do you have any reason to suggest that they won't also follow cost of service rate making?
I have every reason to be concerned. The main reason is because today, when Aquarion sets rates, PURA regulates those rates under a prudency standard. The rates have to reflect prudency by law. The Supreme Court has made that clear. The enabling legislation, which, by the way, none of us should overlook the fact that it was drafted by the applicants, says nothing about prudent review, prudent management, or prudent review of rates. There is no limitation that currently exists in what the representative policy board in the future could adopt.
So do you have any reason to believe that public entities are inclined to overspend? Because the typical narrative is actually that they underspend and that infrastructure lacks investment. So there's sort of a tension there. And I'm going to talk about another tension too, but I'll give you that.
Yeah, I mean, I don't think that I hearken back to the record, because after all, that's what we are confined to here as we discuss it. I don't think that the issue necessarily is that there was evidence that inadequate investment in infrastructure would result. I just don't think that was evidence that came out. What did come out were proposed rate schedules that were frankly outrageous. Talking about passing on a $490 million acquisition premium to ratepayers, and Pura has no say in it. Now is the time for your say, by the way. If you allow this, you're going to be allowing an acquisition premium to be paid by the Aquarion ratepayers. I can't fathom how that's in the public interest. Similarly, the debt service is part of your findings. That the reason the rates are going to be so high, they've guaranteed us that, is because we're paying for both acquisition premium and debt service. That cannot be in the public interest.
Yeah, so let me just follow up on my earlier thought that in the utility economics, realm, we usually actually worry more about investor owns having more inclination or proclivity to spend because of rate-based incentives, and that's why we're here, right? Is to make sure, as you said, that things are prudent and useful, and I'll pick this up later, I think, but because I will be exploring the premium as well as some of these incentive issues some more, but I don't want to get too far away from this. So going back to, I heard a lot of passionate concern, and that's perfectly suited to the spirited debate but I heard concern about affordability and rates. And I hear concern about pilot and maintaining pilot revenues. Who pays for pilot or property taxes?
Aquarion. Aquarion is I'm sorry, the concern with pilot, let me be a little more clear. The concern with pilot is that Aquarion is one of the largest property taxpayers in every single municipality that I represent and that Attorney McLeod represents. So instead of having Aquarion pay property taxes on future improvements, the legislation that they drafted cuts it off and says, we're going to draw a fine line here. Whatever may happen in future improvements on property will not be included in pilot.
Are you suggesting that Aquarion's investors are paying property taxes? Who's paying the property taxes?
Well,
I think it's ratepayers, right?
Well, you're asking a different question, which is whether those property taxes paid by Aquarion then ultimately get passed on to ratepayers, if I'm understanding the question.
Correct.
And I think the answer to that is, even if that is so, to a degree or even entirely, we have the comfort of knowing that Pura is reviewing those rates, that there is regulatory oversight. And that's the critical point.
Actually, we don't get to decide property taxes. We don't get to decide any taxes, and taxes do impact customer rates in very significant ways, federal, state, local, and that's a separate issue we could also talk about. That is an investor-owned utility as a private entity is subject to income taxes. So in addition to the cost of capital, income taxes are another item we sometimes forget to talk about, but it does also affect the cost of service because these are legitimately recoverable costs under our regulatory model. So I'm, feel free.
Then I think that to cut to the chase, then if the hypothetical is that, if ratepayers are suffering in the Aquarion region because property taxes are being passed on to ratepayers, then why consistently, year after year, decade after decade, has the public model in the New Haven region and RWA have rates been consistently higher than in the Aquarion region? So however you put together those multiple elements that ultimately get into the rate base, that ultimately get passed on to consumers, it is undisputed that the rates are higher in the RWA region and lower in the Aquarion.
Is there any statistical analysis in the record, and other parties can feel free to come at this later? Is there anything in the record that would demonstrate the causal factors behind rates? Because rates vary for a lot of reasons. And frankly, the number one reason is variation in the cost of service. Could be where they are in the infrastructure construction cycle. It could have to do with geography. accessibility to high-quality water sources or not. It could have to do with compliance with drinking water standards. And it tends to vary, as we know. Systems are in, various stages of their replacement cycles or meeting federal and state standards and so on. So there's lots of explanations for why rates vary. In a cost of service world, the rates should reflect the cost of service. And while we might be unhappy about it, because if our rates are higher, there may be a reason for that. So I guess I'm asking, is there, other than just looking at averages, is there a study that we could see that would demonstrate that there's something going on, given that these are two cost of service utilities?
Yeah, and I'll answer the first point by punting and asking one of my colleagues, Attorney McLeod, to pick up on that. But more to the point, I don't think it takes a lot of in-depth analysis to understand that in one region there's regulatory oversight by PURA and in another there isn't. I'm certain if there was no regulatory oversight, Aquarion's rates would have been much higher, as we know. And it has been PURA that has been the backstop, PURA that has protected the ratepayers in this state. And that is the fundamental distinction.
So much so that it offsets the higher cost of capital and the income taxes.
Absolutely, because at the end of the day, and I keep coming back to it, the rates are the final determinative proof as to whether regulatory oversight works or doesn't work. Thank you. I know we're kind of jumping around. I'll move off any financial issues because I think you've just hit on them squarely. Let me make, if I may, just one other point following up on OCC's arguments about the OCA. And this is, we really believe, a problematic aspect of your draft decision. So the OCA, by law, under the enabling legislation, has to be an advocate for consumer interests. Okay, that's section 41 of the enabling legislation. As Judge Budzik concluded, yes, there is a legislative mandate that if this transaction happens, OCC will be gone, OCA will replace OCC as the consumer advocate. But that doesn't mean that the legislature ever spoke to staffing, budgeting, expertise, independence. And PURA, you correctly concluded after the evidentiary hearings that the OCA experience in the RWA region was a problem and not in the public interest. The evidence was that in 25 years, OCA only objected to rate increase proposals 3 times and was ignored all 3 times by the Representative Policy Board of the RWA. In your initial decision in November, you concluded properly that in practice, the OCA fails the managerial suitability standard and is not in the public interest.
No, I'm just going to ask our friends over here, just try to keep everything on silent, and we have to keep an orderly and procedure to today's hearings. Thanks. Sorry, Attorney Ball.
No problem. Thank you. Nothing has changed since the initial decision. There's no new evidence. There were no new evidentiary hearings. OCA, you're finding that it is understaffed, underfunded, and not independent doesn't change. And Judge Budzik made very clear that that was an appropriate conclusion and something that you had every right to conclude in November, okay? The modified offer of compromise, which you cite to in this draft decision, first of all, we wholeheartedly agree with the OCC argument in their brief that that's out of bounds for you to consider. It is out of bounds because we never had any opportunity to cross-examine witnesses. We had no evidentiary hearings on that one-sided document. It is not an agreement between the parties. It's simply a statement, supposed promises by the applicants that has never been challenged. There is a major due process concern if you base your conclusion that now the OCA is in the public interest based on the modified offer of compromise. And I'll be more specific. On page 7 of your draft decision, you cite that The only aspect relating to the OCA in the MOC is a non-specific promise to add sufficient staffing to the OCA to address customer concerns for each authority. Now, first of all, again, we don't think that is relevant. We don't think it's proper for you to consider. We think it's a due process problem if you do. But even if you did, how in the world does that change your conclusion? These are, by your own draft finding, non-specific promises. You can imagine the frustration for the towns that currently have a robust consumer advocate in the OCC. We see OCA understaffed. We see OCA not funded adequately and completely beholden to the water authority. So there can't possibly be an independent consumer advocate. And in November, you found that is not in the public interest, which we wholeheartedly agree with. And now, a few months later, exact same factual record, nothing's changed, and you've abandoned the conclusion. Judge Budzik made it clear. This was fair ground for you to consider. This was not predetermined in any way by the legislature. And respectfully, I don't see how it is possible that this failure with respect to the OCA, failure of public interest 4 months ago suddenly meets the public interest standard. On this ground alone, we would urge you to adhere to the prior decision. That is grounds enough for the denial of this application. And I don't think that the new decision can be reconciled with the November decision on that issue, on the OCA.
Was that, are you concluding at that point? Okay, excellent. All right, thanks. Thank you.
I'm sensing you're hoping that I.
I think I'm going to sense, you're going to hope I will conclude
I'm
at some point. So,
Now's the time.
yeah. I just had one, I think one or two last questions. How do you counter the applicant's assertion that the opposition to the transfer and transaction is coming from a vocal minority?
Because first of all, it's absolutely untrue. I mean, the evidence in the hearings, in the evidentiary hearings that we had, was that every one of the participating towns, and by the way, we have MetroCog and WestCog here representing 27 municipalities. It's all the municipalities in the Aquarion region that are opposed to this. There was not one scintilla of evidence, not one. Nowhere can you find it in the record that any town in the Aquarion region supports this.
And other than proceedings before PURA and judicial proceedings, were there any other institutional means of addressing this challenge in terms of mobilizing not just towns, but residents, ratepayers around these issues? Were there any other activities that you'd like to share?
I mean, the only, first of all, it's anecdotal, and to be fair it's not within the record. The public outcry in the towns I represent has been staggering, and I assume Attorney McLeod will tell you the same thing. The towns have invested an enormous amount of money in attorneys to advance these arguments. This is a critical issue for the towns, and we really are urging you to not accept this as, not accept that the enabling legislation makes you a rubber stamp. As Judge Budzik said, your powers go way beyond that to consider the public interest. We really urge you to reverse this decision.
I think we're good unless you have.
I don't.
Okay.
Thank you very much.
Thank you, Attorney Ball.
Yep.
Cogs.
Good morning, Vice Chair Conti, Commissioner Beecher, Commissioner Cheeseman. I hope you'll allow me one moment before I get into substance, and that is actually to express gratitude to the utility workers from both Eversource and Aquarion, who came out in some horrible weather conditions to restore both my water and my electricity at one point. These are the folks who really do the hard work that gains high marks for both Eversource and Aquarion for customer service, and you know, they're too often just overlooked. But when you come out in the dark and it's near zero and you fix a problem, that deserves acknowledgement. However, it doesn't mean that I support the application. I read the draft decision, and what I saw in the draft decision was a feeling that you had properly identified issues with the proposed transaction and the application back when you unanimously rejected it in your November decision. I also read in the draft decision that there was an acknowledgement by Pura that the problems you had identified back in November would persist. They wouldn't go away just because a judge's interpretation of the statute was that you didn't have a right to review the entire application according to your normal statutory powers. As Attorney Ball indicated, the judge's decision is on appeal. We would like to see you able to apply your full powers, as we believe the legislature intended, to the review of this change of control application. Those would be the normal powers under 1647, 1622, 1611, and 1619E. I read these things in the draft decision, and it was my conclusion in reading it that if you were able to exercise your full powers, you would be able to reach that same decision that you reached back in November. I also read the draft decision as an expression that you didn't think you could exercise all the powers that the court in fact left to you. You kind of pulled your punches, in my estimation, in reviewing the application on remand. David Ball has already indicated a position that I would agree with, as did the OCC, and that is that there was no change which justifies a switch in your analysis of the inadequacy of the Office of Consumer Affairs as proposed in the application. You found that the OCA setup was inadequate, that it was a poorly staffed, under-budgeted, and non-independent consumer advocate that was basically managerially unsuitable. You found that that was one prong in your conclusion back in November that the application did not meet the public interest. Nothing has changed. There was a draft decision, there was, of course, a judicial decision, but that judicial decision did not interfere with your analysis of OCA and its unsuitability. If anything, it was an invitation to you to come back and just say, look, we stand on our conclusion that OCA was managerially unsuitable, and further that because of that, the application is not in the public interest. If you review the two things that were taken away from you by the remand decision, that would be your accurate identification of the shortcomings of the governance structure, the potential conflict of interests in it, the disenfranchisement through the RPB weighted voting rules of a significant number of communities within the Aquarion service territory. You stated in the draft decision, I don't know if you did, but the draft decision states essentially that those problems will continue. It seemed as if you wished you could do something about them, but You realized that that would have to be left to legislative change or some sort of accommodation among the parties. I can tell you that my experience in the course of this proceeding is that there probably will not be accommodation among the parties. Certainly, the prospect of legislative change has been broached, and it has been kind of a iron dividing line on the part of the applicants that they will not change the legislation. That was suggested in testimony a few times, and it was just, well, that's the way the legislation is for the time being. So I do not see accommodation among the parties as any sort of.
If I can jump in here.
Yes, yes.
So if I'm understanding correctly, one, you and I, we obviously we will let the applicant speak late. We will hear from the applicant later. But no sort of accommodation on the part of parties would bring the towns you represent around to accepting this decision.
Nothing that has
just-
been. I don't know. I don't want to. I can't guess at what
Or
accommodation.
you're guessing whether or not, and you're saying you don't think any
Okay.
accommodation could be reached. So that strikes me
Yes,
as a
that's
guess
fair.
as well.
They have drawn the, I was distinguishing in terms of your draft decision between the possibility of fixing it through legislation or accommodation by the parties.
Okay.
The applicants have suggested that they will not change the legislation.
Well, they themselves can't change the actual legislation as
They
it stands,
cannot
but
change it,
if they
but
wanted to alter,
they did testify, and it's in a footnote in a brief that I submitted, that they have worked with legislators to change enabling legislation several times, but they didn't choose to do it here. And
nor did the rest of the people appearing before us, but we've already gone down that road. So I'll stop interrupting you and let you continue.
all right, well, thank you. At any rate, my point was that I read the draft decision as suggesting that if you could, you would like to fix the problems that you see as unfixable unless changed by legislation or accommodation by the parties. That being the case, I would think that you can reach that same result, and that is by exercising your full powers, as the court said was your duty, not an option, but your duty, to review the transaction, applying your full statutory powers that were left intact by the court, and reaching conclusions based on the record, which has not been changed, that are consistent with your November decision, at least with regard to OCA. And there are other reasons too, which I think you can exercise within the statutory powers that the court recognized are yours, which would also enable you to reach a conclusion that this application is not in the public interest, and I'll get to those. But first, and I recognize there's some risk in making this first because it has sparked so much conversation. But I would echo what both the OCC and Attorney Ball has said so far, that there is a serious problem, and I would call it legal error, as did Attorney Ball, in the draft decision's obeisance to the legislature as having expressed a strong public interest in a public ownership form of government. I don't think 24-1 stands for a legislative preference for public ownership at all. If the legislature had wanted this to go to public ownership form, the legislation would have said two things. It would have foreclosed any bidding by an investor-owned company, and it did not. And it would not have had an expiration date, as it does. As Attorney Ball said, I do want to address, since you raised it before, Commissioner Cheeseman, and may again raise it, so maybe I can address the question in advance. Why is it so prescriptive then? I think the answer to that is that it was drafted, as testimony shows, by RWA. It was essentially a copy of the legislation which created RWA. But there's a key distinction that has not been brought up yet. And that is that the legislation which created RWA did not require any regulatory approval, none. This legislation does require regulatory approval. And so in copying basically the verbiage from Special Act 7798, that's just how this came about. And I think it probably also bears mention that the manner of passage here did not permit very much public input. It was done in special session as emergency legislation as part of an omnibus bill, which addressed, as you well know, a number of other things: schools, taxes, conservation, things like that. The legislature was voting on a number of things, not simply this. But
By their choice.
I'm sorry?
They chose to do that.
They did, yes. I am not disputing that this is validly enacted legislation, but in answer to some of the questions about why is it so prescriptive, et cetera, I thought that would be helpful background. I also want to comment again on Judge Budzik language, where he said basically that it was up to PURA in the first instance, exercising all of its, taking into consideration all of the relevant statutory and policy considerations to make the public interest determination on this application. I guess the question would be, how can PURA in the first instance make the public interest determination if the starting point of your analysis is that the legislature has expressed a strong public interest? I don't know how you make that first instance determination if right away you begin by saying the legislature said. And I don't think, by the way, as has been expressed by many in this room, but two others in this room, take that back. I don't think the legislature in any way expressed a public interest in the section that Attorney Ball cited. It expressed the fact that AWA or RWA, as the case may be, would be serving a public purpose. The same thing can be said of Aquarion back in the 1857 legislation, which created it for a public purpose. The same thing could be said for the predecessors of Connecticut Water or Torrington Water when they were created by legislative act back in the late 1880s, 1870s. They were all created for a public purpose, and that's no different from what's done here. AWA is created for a public purpose. That is not the same thing as saying we prefer that a public authority be the owner and operator of this water supply system, as opposed to an investor-owned utility.
Attorney McLeod, so we are a creature of the legislature. And so our ability to evaluate the public interest has to, is bounded by the statutes, as well as the Constitution under which we operate. So there is a tension there. I understand it, and frankly, it's something that we need to think about. What is the legislative role in defining public purpose and public interest? And then what gets delegated to us? So these are not easy questions.
And the court wrestled with that, Commissioner Beecher. The court made clear that you were delegated by the legislature certain statutory responsibilities. Those responsibilities include the exercise of full regulatory discretion under Section 1647D when it comes to applications for changes of control. You're expressly given the duty by the legislature, according to the court in reviewing this application, to exercise your statutory responsibility with respect to the determination of public interest. It was the court interpreting the meaning of the legislation that binds you, that said it is up to PURA in the first instance, taking into account all the statutory and policy considerations which bear on the public interest, to make the public interest determination. The court did not say that that was one of the areas which had been legislatively preempted. It said it was up to you in the first instance. Doesn't mean it's not subject to judicial review, but I will repeat what Attorney Ball said. I think it would be legal error for you to conclude that the public interest question regarding a preference for public authority ownership has been decided by the legislature. I don't read 24-1 that way. I don't believe the court read 24-1 that way, or it would not have said it is your determination to make in the first instance. There is no way you can make the first instance determination if you've already let the legislature do that. And if that's where you start, there's no way, regardless of the other verbiage between that statement early on in the draft decision and the conclusion, that can possibly alter the inevitable conclusion that this is in the public interest. If you made that statement up front, there's no way in the back of the decision you can change course in between and say, we're rejecting it because it's not in the public interest. And that's a shortcoming of the draft decision.
So in effect, what we said at the beginning carries through to the end. I mean, we're being consistent from your point of view and having decided that at the end of the day, the legislature has the guiding hand on this. Then, am I following your reasoning?
I'm saying if that's the starting point of your analysis, it's very hard to reach any other conclusion. And I don't believe that's.
And you feel the starting place of our analysis was in error?
Yes, I do. Clearly.
All right. Thank you.
I clearly, thank you. And so I would say that you are staring another administrative appeal in the face if that language stays in the decision. So that's what I have to say on the preference, public interest preference for public ownership. Any questions on that point?
This is somewhat related, Attorney McLeod. Am I remembering the record correctly that you raised in either prior oral argument or the hearings the concept of AWWA operating as on a standalone basis as a public authority? And if like down the line, it might have been just a, just a general thought that you shared.
Mhm.
And would that change the posture of your clients or your arguments?
I think, Commissioner Beecher, what you may be referring to is, I can recall a couple comments. The first I recall is saying that it had not been proposed in this application that AWA operate as a standalone, and therefore, whether or not AWA was able to operate as a unaffiliated, I should say, unaffiliated standalone without RWA involvement was not a question before the authority, and therefore the authority in this application, in this version of a proposed public ownership model, couldn't rule on that
Okay,
point.
and I raise it because that sort of separates the issue of ownership character from the particulars of this, affiliation. And so would different arguments apply if this was a straight up transformation of Aquarion to a public authority?
I think there would be a number of different arguments to make. I mean, governments, the whole issue of governance structure, conflict of interest, et cetera, wouldn't be there if RWA was not involved. There wouldn't be a question of an expanded authority board and recusal and conflicts and cost allocation. Those things wouldn't exist if it was, as was the case when RWA was formed, a single authority with only residents of that area on the board without possibly conflicting dual fiduciary duties. So it would be a radically different issue.
Thank you.
So to conclude this portion of it, I urge you to exercise your full powers, to heed what the court said about it being your duty to exercise your statutory responsibilities to make the public interest determination yourselves. The only thing that may have changed, I suppose, and it isn't a change, is the assertion by the applicants that you ignored the mock. I called it a mock. I don't know whether we're referring to it that way yet or not. The modified offer of compromise. For shorthand, I will refer to it as mock as an acronym. I heard what the OCC said. I heard what Attorney Ball said. And I will, as a default, subscribe to those views. On the other hand, I do want to point out a couple of things. Number one, the mock was, in fact, the commitments. Many of the commitments that were proposed in the mock were, in fact, attached or were set forth in the brief submitted on August 22nd, 2025, with respect to the main case here. The pages, I believe, are something like 55 to 64, or maybe 53 to 64. There's a table of commitments, and then they were updated later on in the applicant's reply brief. So the applicants put these so-called commitments before you, not only through the mock, but in another form. First of all, you're not required by 1619 JJ to consider and approve an offer of compromise just because it's put before you. That statute uses the word may when it talks about what you can do. It doesn't say you shall. And so consequently, it's your discretion as to whether or not you're going to entertain an offer of compromise or not. There was no compromise involved here. That's the label that has been put upon it by the applicants. So.
Sorry, I'm just going to jump in there. So if the offer of compromise inclusion is merely to document the promises made by the company, I granted that if this transaction goes ahead, Pura's statutory authority to govern or police those agreements is removed. But if this is a documenting for the purpose of the record, the offer of compromise made by the company and including it in the final decision, which we may or, which you, according to you, we have the ability to do.
Sure. Well, if I understand your question, and if I don't, please clarify. But an offer of compromise was proposed and then it was modified. Both of these things were put on the record in the form of offers of compromise and also a motion for you to approve it. You're not required by 1619 JJ to approve just because it's put before you, and you're not required by 1619 JJ to even have a hearing if it's put before you. That does not contradict what has been indicated by OCC and Attorney Ball, that if you do approve it, you should have a hearing and you should afford due process to all the parties who would be affected by it. That's a separate issue. What I'm saying is simply you didn't have to consider it in the first place. That's number one. Number two, what is in there, and you mentioned the issue of enforceability and documenting these commitments. What is in the mock are more in the way of empty promises than enforceable commitments. For example, the unspecific promises regarding OCA. For example, the statements that after 3 years, they may consider legislative changes. That's not a promise. They have it listed as a commitment. It's listed in the mock. That's not a promise. There are other things of the same nature that are wishy-washy and by no means hard commitments with definable goals and ends. And then you get to the issue of enforcement. It's very different for two parties to enter into a settlement agreement when they are regulated by PURA, because you can get a rather quick remedy if there is non-compliance with a settlement agreement simply by coming to you. That's gone. That recourse is gone once you approve. And the idea that, well, they're going to get a pre-closing, they're going to get things to you pre-closing. You have no jurisdiction over them. The date, the moment you approve this transaction. So if they send in something to you pre-closing, but you've approved the transaction already, you have no enforcement jurisdiction over that. And by the way, a couple of the things that they propose to do pre-closing, they propose to take care of the conflict of interest issue and the cost allocation issue by filing a cost allocation policy and also a conflict of interest policy. But when you read what the mock says, it says that the condition to closing shall be satisfied upon filing of that document with PURA. It doesn't say anything about PURA being able to review the document. It doesn't say anything about whether the contents of the policy, either one, are satisfactory. In theory, they can send in a piece of paper headed conflict of interest policy that says it's our policy not to engage in conflicts of interest. And the fact that they file it according to the wording of the mock means we've met the condition. That's empty. Doesn't get much more empty than that. There's one other aspect that deserves comment in the mock. They have offered, I guess, they meaning the applicants in the mock, have offered to lower the RPB threshold level for projects from a minimum of 3.5 million to 2 million. I don't know if I expressed that well enough. Do I need to be more clear on that? There is a statutory, there is a element in the statutes that indicates that the authority board may initiate projects of 3.5 million or below without RPB approval. The applicants have offered in the mock to lower that 3.5 to 2 million. So in other words, you would need to get, according to the applicants, RPB approval for projects as low as 2 million. They invite you to incorporate that into your order. Let me submit to you that that would be beyond your statutory authority. You'd get into the same sort of difficulty that Judge Budzik found you in his administrative decision order, because the statute specifies that it is required of the APB to approve once it gets to 3.5. And another way of putting that is that the board, not the policy board, but the AWA board would have the right under the statute to approve projects up to 3.5 million. Those are specified in the statute. They cannot change it, and you cannot accept that change without modifying the express terms of the statute. So that would be illegal. There may be other parts there. There's something as well in the mock about bifurcating the board vote so that after 3 years, AWA would vote. The AWA members would vote only on AWA matters, and the RWA members would vote only on RWA matters. That is not what the legislation says at this point. There is a reference in the.
Sorry, if we're accepting that the applicant was the one who designed the legislation in the first place, surely it's not unheard of that if the applicant has all this power, they would have go back to the legislature and ask them to change it to accommodate this modified offer of compromise. And this is all speculative, of course, and I
Yes.
appreciate your pointing out the areas where somebody needs to do something to make this work. Thank you.
Let's take the applicants out of the picture. They're putting you in the posture of being reversed on a, what I would guess, if the decision is rendered on March 25th, you stand the risk of being reversed because you have exceeded your authority by incorporating a feature in your order that runs counter to what the statute currently says. I think the parties here would be happy to go back to the legislature and work out something that worked rather than this.
Why hasn't it happened? Well, I mean, this is we're talking summer of '24. I hear everybody saying we have all these problems with it, and yet if we accept that the avenue to fix this was through the legislature, it's somewhat frustrating to hear people saying, well, actually, we haven't done that. And I'm just voicing my frustration here. Obviously, we're here because we're here to hear everyone's argument on the basis of that proposed final decision and to weigh that up as we go forward.
There were talks in response to one of your questions, and I don't think this is exactly what you were asking, but there was testimony that representatives of RWA made visits to various towns within the Aquarion service area, got feedback from them that they were unhappy with certain parts of the proposal, and indicated that they would take that under advisement and go back and see what they could do about it. So I don't know whether that could have been a reason why towns held back. I do know that there was an effort to get something going in the legislature, perhaps back in February of 2025. There is currently an effort to get something going, but there was also an application filed in, I believe, well, let's see, 2504. So it would have been April of 25 when this application was filed. And at that point, it was before Pura. So I don't know whether that answers your questions. And then, of course, there was a decision that was.
I think it was more rhetorical than anything else, Attorney McLeod, but thank you.
I'd like, I'm going to stand on the written exceptions in the briefing for a number of other points that are made. And we don't waive those by the fact that I failed to mention them. Time is limited.
Just clarification, I should have said this at the beginning. All the panel of commissioners have read all written exceptions, just to
Thank you.
bolster that.
Yeah.
Attorney McLeod, thanks.
Right. Well, then you know that the final point I raised in my in our joint written exceptions had to do with the propriety of the acquisition premium being placed upon AWA ratepayers alone when RWA has indicated that their ratepayers will also benefit. This is a transaction that was not wanted by AWA ratepayers. It was an the proposed transaction was basically the result of the bidding by Eversource or in response to Eversource by RWA. So that gave birth to this transaction. AWA towns and AWA ratepayers were not consulted beforehand. And in that regard, just as a historical point, this application, again, is very different from what happened with respect to RWA's formation 45 some years ago. There were 3 years of public debate before 7798 was enacted. And part of that debate involved give and take, and also involved the requirement that 60% of the towns in the service area consent to the formation of RWA. So there was local consent involved when RWA was formed. That element is totally missing here. AWA towns weren't consulted beforehand. There was no public give and take beforehand. There was no public input at the legislative hearings. And so consequently, there has not been consent, yet the real purchasers here are AWA ratepayers, because they're the ones who are going to be paying the freight for this transaction. They're going to be paying the debt service. They're going to be paying the acquisition premium. The transaction, on the other hand, as RWA has said on pages 48 and 49 of their brief, on page 33 of their reply brief, and on page 18 of their remand brief, this transaction will benefit RWA ratepayers. I'm not sure when or how it became acceptable in the state of Connecticut for the ratepayers of one system to pay the costs of benefits for the ratepayers of another system. That is shocking. It also raises another question. And this is a question that goes right to the conflict of interest issue and the cost allocation issue that was identified in the November decision as a problem. And that is, RWA is on both sides of that negotiation. It's on both sides of that arrangement. RWA has a conflict. It is a huge conflict, and it's been here in front of us the whole time, and somehow it was perhaps so massive we didn't see it. It's here now. They want to impose an acquisition premium, which the longstanding policy of PURA and its predecessors is against. They want to impose an acquisition premium and other costs related to the purchase on AWA ratepayers who were not in favor of this, so that RWA ratepayers can benefit. There was no negotiation here. This is strictly done by RWA. That's a conflict of interest. It's wrong. It doesn't follow cost of allocation principles. It doesn't follow cost of service. You're going to be putting in rates something that does not reflect actual cost of service. And I'm going to remind you, you've read the written exceptions, so you know that there was testimony to this effect from Aquarion and RWA, that they said no reviewing board, whether it be PURA or the representative policy board, would ever approve an increase in rates unless it was based on actual cost of service. The acquisition premium is not actual cost of service. Yet you suggest willingness to put it into AWA rates on the reason that, well, you won't have jurisdiction over AWA rates anyway. It should never reach that point where you lose jurisdiction, because you should find that that conflict of interest, that imposition of a sizable cost on AWA ratepayers in order to bestow benefits and cost savings on RWA ratepayers is unconscionable. You shouldn't want your names on an opinion that okayed it.
Isn't that how the statute structures AWA and RWA?
The statute, again, does not go into rate making. It doesn't go into your prerogatives to review rates to assure that they are in line with 1619 EA4, 1619 EA5, or 1647. You review the rate structure in the draft decision, I believe, under the 1647 D1 criterion of financial suitability. I think that's where you have rates. I'm suggesting strongly that it is not financially suitable for AWA rates to have an acquisition premium in them that is tied to a transaction which benefits not simply AWA, but also RWA, and RWA ratepayers get away paying nothing. It's all on AWA ratepayers' backs. That's shocking.
So is
And-
will
and-
AWA be defined, public service companies defined in 1619E, but that the AWA doesn't fit that definition?
No, but 1619 does require you to regulate the transfer of water company franchises. I think you yourself in the draft decision, I'm sorry, I don't mean to say you, Vice Chair, but the draft decision itself indicates that the statutory scheme in Connecticut under Title 16 is to achieve just and reasonable rates. And there is no way that it is just for AWA ratepayers to assume the entire burden, especially when that burden consists of something you do not normally allow, an acquisition premium. When the RWA ratepayers will get a benefit for free. And you put on top of that, who was the chef of this? It was RWA on both sides. RWA is not allocating any costs here. RWA has a conflict of interest because they are representing both their ratepayers and AWA ratepayers in this.
I'll follow up.
What?
I'm all set.
Oh, okay. For these reasons, I don't see how you can find this application to be in the public interest. I don't think it meets the criteria of 1647 D1 in terms of financial suitability, given the rate structure. And you are called upon to consider the rates. You did consider the rates in the draft decision. I think you did not evaluate all the way whether or not the rates conformed to 1619E, which does obligate you to regulate transfer of water franchises,
So,
regardless of public service company or not.
all right, so, right, Aquarion has hundreds of millions of dollars, right, in capital spending that's not yet in rate base, 80-something million dollars in PFAS remediation, around 40 in lead line replacement. So, right, under this new model, all those costs, there'll be no equity layer in income taxes on all those costs. So what you're at, am I hearing you correctly that the current investor-owned model, you're advocating that the current investor-owned model is in the public interest for ratepayers?
Well, I'm saying that this proposal with this model is not in the public interest. But with respect to your observation that there are these areas where there may be savings. And by the way, your draft decision was not as firm as to say that there are definitely benefits. It expressed serious misgivings, and it expressed the fact that the rate savings were uncertain and mixed. So that's where we're starting from. But in terms of the benefits, there are theoretical benefits which may help. I'm not denying that. On the other hand, by packing current rates full of an acquisition premium and a purchase price, you are detracting from the use of current rate revenues to pay for capital investment. So in addition to whatever will be required for capital investment in the future, you've got this big space already taken up in rates. And if that space were lower by disallowing the acquisition premium, there would be more room in rates, lesser rate increases by dedication of some of that rate money to capital investment.
I don't think the panel has any further questions.
May I just take a quick look at
Sure.
my notes, which were really scribbled all over the place? I
There will be another round.
know there, beg your pardon?
There will be another round.
All right, well, one quick thing. There was a comment on a vocal minority. There is no vocal minority within the Aquarion Service District. That is a vast majority who are opposed to it. And when you compare this, again, with the formation of RWA, RWA had a consent requirement. So you knew when RWA was formed that 60% of the people approved. So you had a majority saying, okay, this is fine. Totally absent here, and that's why, in terms of public interest, this is an unprecedented transaction. You've never had a public authority come in here and say, we want to sponsor the acquisition of another authority. They're not acquiring it. They're saying AWA is acquiring it. Understood. But by the same token, there is an element of everybody on the state, if you want to take it from a legislative viewpoint, voting on this, as opposed to the affected people voting on it. The affected Aquarion public has not been consulted by the applicants on whether or not they want.
Attorney McLeod, did anybody suggest the idea of a referendum?
This was already, not to my knowledge, this was already before you when I came into the picture. And I think instead, RWA had this legislation passed and it started making visits to towns, which I gather weren't entirely positive, if positive at all.
And if they did, would we have statutory authority to consider the results of that referendum?
Had it been in the legislation, I think you would have known whether it met that requirement or not. Had there been a referendum, I think you would have had authority to consult that as an indication of public feeling. After all, again, the real purchaser here is not AWA. They're styled as the owner, but it's the ratepayers of Aquarion who are paying everything for this. RWA pays nothing, not a dime. Their ratepayers pay not a nickel. And so you're really looking at the AWA ratepayers and the AWA towns. And that's really the voice that should be heard.
Thank you.
Okay.
Thank you very much.
Thank you. Attorney General.
Good afternoon, just by a minute. William Tong, Attorney General here for the state of Connecticut. I want to thank you, Mr. Chairman, and the commissioners and the authority for the privilege and the opportunity of appearing before you today. And in particular, if I may, I want to thank the staff of PURA for their extraordinary work for ratepayers every single day. I want to thank the Consumer Counsel for her excellent presentation and her staff. They do such a great job for all of us. And for the record, the state adopts the arguments and positions advanced by the Consumer Counsel. So some of you may be wondering, what's he doing here? This is a big deal. This is a very consequential decision that affects more than 720,000 people in 62 cities and towns. And I thought it was important, it is important, that I come here to convey the state's position on this transaction. I want to be clear about this. I'm not here to convey or communicate my personal opinion, my staff's opinion. This is the state's position. Under Connecticut General Statutes 3-125, the Attorney General speaks and acts for the state on all legal matters. And I want to say, as the state of Connecticut, that Aquarion is a very good company. It serves its ratepayers and communities well. And this transaction puts all of that at risk. You have heard from senior state officials, legislators, legislative leaders, senior municipal leaders, advocates, ratepayers. There's no vocal minority. There is a very angry majority out there, and nobody wants this deal. So I'm here to make it as clear as I can. The state of Connecticut opposes this transaction and urges you to disapprove this deal because it is not in the public interest. So how do I know it is not in the public interest? Well, I know because you said so. Pura has said so over and over and over again that this transaction is not in the public interest. You said so 10 days ago in your decision on remand on the very first page on March 6th, quote, "This authority continues to have serious misgivings about the financial terms of the transfer." Serious misgivings. A decision which this authority makes with serious misgivings is by definition not in the public interest. How can you say that something is good for ratepayers, it's in our interest, if you have serious problems with it? I must tell you that as a legal matter, it is a breach of your duty as commissioners to approve a transaction about which you have serious misgivings. Think about how this sounds to the more than 700,000 people out there, all of the ratepayers outside of this room. This is what you're saying. We, Pura, swore an oath to protect ratepayers. We are really worried about this deal. We have very serious concerns about the cost and impact on all of you, and we have the full power and authority to stop it. But we are going to make you pay for it anyway. Actually, it's worse than that, because you already rejected this deal. So what you're actually saying is, we, Pura, already said this deal is no good. We rejected this deal. We already told you in just under 4 months ago, in 31 single-spaced pages, that we think this deal is not in the public interest. We still have serious misgivings today, but we are now reversing ourselves, and we are making a choice, Pura, to make you pay for it anyway. You rejected this transaction not even 4 months ago on November 19th, 2025. 4-0. 4-zip. 3 of the 4 commissioners who voted against this deal are sitting here today. The ink is not even dry on that decision. Nothing has changed in the last 4 months. But now you say, we changed our minds. Let me remind you what you did less than 4 months ago. You made a legal and factual finding that this transaction is not in the public interest. You did not issue an advisory opinion. You did not issue a draft decision. You made a final binding legal and factual holding, like a court, that this deal is rejected. In that first decision on November 19th, you said, quote, "The authority finds that the proposed transaction does not meet managerial suitability and responsibility requirements in a manner consistent with the public interest." You rejected this transaction because of, quote, "incompatible fiduciary duties in the board structure." In other words, you rejected this deal because there is an inherent conflict of interest on the expanded authority board.
The board structure is created by statute, right?
Yes, it is.
Why did the legislature do that?
The legislature did what it did, but you observed there's a conflict of interest on that board. And what you observed is that you have,
So, with due respect to Judge
Yes.
General, Judge Budzik on remand said those details regarding the structure of the governance board, those issues relating to conflict of interest were outside our purview because they were the creation of statute.
with respect, Commissioner, he did not say that. With respect, Commissioner, Judge Budzik said, and I will get to this at length because I know that's what's holding everybody up here. What Judge Budzik said and the Superior Court's opinion and order. Judge Budzik said that you can't deny the application based on the membership of the board, based on the formula by which the board votes are counted, or that the Office of Consumer Affairs is the ratepayer advocate. You can't argue with the structure. If you approve this deal, you have to do it the way the legislature said, but you don't have to approve it. You can decide that it is not in the public interest because, for example, you don't like the budget of the Office of Consumer Affairs. You don't like that the Office of Consumer Affairs is an office of one person who works 6 hours a week, who gets paid $60,000 a year, maybe, if they approve the invoices. That's, by the way, half the cost of a junior assistant attorney general in the state of Connecticut. And if you don't like the lack of independence of the OCA, you can reject this deal. That is what Judge Budzik said in clear, plain English. And so he is also saying, if you don't like the conflict of interest on the expanded authority board or on the RPBs, you can also reject this deal. You just can't quarrel with the structure that the legislature laid out. And so this is why I wanted to remind you that you already found there's a conflict of interest. And let me tell you how this conflict of interest plays out. In December, we all watched in horror as 100,000 residents lost water in Waterbury due to a catastrophic water main break. Now, admittedly, not owned by the applicants. I am told, I've learned a lot about water mains. I am told that the industry standard is to replace water mains and pipes at a rate of 1% a year. That's every 100 years, water pipes get replaced. Aquarion, to their credit, is working to get to 1%. They're not quite there yet, but they're trying hard. RWA's rate of replacement in this record is 0.23% a year, at least 400 years. In the record, there are suggestions that it could be as high as 500 years. And so you've got an industry standard of replacement every 100 years, but RWA, which is taking control of this entity, does it every 400 or 500 years. And so there's a very real possibility that RWA will focus on its water mains that are desperately in need of replacement at the cost of Aquarion AWA customers. These conflicts are real and potentially devastating. You also noted that you didn't like the lack of representation for half the towns on the resulting board. But what you really focused on was the consumer advocate, the Office of Consumer Affairs. That's what really troubled you. And you said, quote, it is not an independent consumer advocate, quote, not managerially suitable due to a lack of meaningful independence. And that's why you said this setup, quote, your words, is detrimental to current customers and therefore not in the public interest. That has not changed. Nothing has changed. On your remand, in your March 6th decision 10 days ago, you restated many of the serious misgivings about the financial terms that you articulated in your first decision. You said, first of all, that PURA must find that the transaction results in, quote, just, reasonable, and adequate rates. Based on the applicant's models, ratepayers will get crushed by the entire $5.895 billion cost of this transaction. almost $6 billion. Their monthly rates will double for sure in less than 10 years. These rates are not just, and they are not reasonable. You said that applicants will incur substantial costs above the value of the assets from servicing the debt associated with a purchase. Post-transaction, debt service would constitute a large component of the AWA cost structure and ratepayer burden. And you said the authority is concerned about the rate impact of the transaction as structured. You are absolutely right, commissioners. You are absolutely right.
Sorry, Attorney General, where did you get that $6.985 billion cost?
5.895.
5.8, where did that?
It is in the applicant's model. This document, I believe it is in the record.
That's not the transaction price.
If I may, if you look at the senior acquisition bonds and the debt service on the senior acquisition bonds, plus the debt service on the subordinate acquisition bonds, all of that totals up to $5.895 billion. It's not 2.4 billion. You got to add in the interest. So it's book value, right? It's book value plus debt service, and altogether you get up to book value, debt service, and acquisition premium, and you get $5.895 billion
So that
in total
includes
cost.
the cost of all interest over the life of the bond?
Yes, 40 years of
So,
interest.
But an investor-owned utility would have costs, if we're forecasting into the future, would it not?
Commissioner, that is not the transaction before us today. The transaction before us today is the transaction proposed by the applicants.
If the
Whether or not, may I finish?
Yes,
Whether or not an investor-owned model would have a different cost structure or additional costs, we're not qualified to say today because that's speculative. I'm good.
Well, I believe much of what we're talking about is speculative, is it not?
Commissioner, that's why I want us to stick to the record. I don't think we should be speculating.
I agree
I think our job
100%.
is to look at the record as presented to this commission.
And going through what is in the record, based on the fact that there will be no income tax and the lower cost of borrowing in the long term, this will in fact result in lower costs for those ratepayers, will it not?
I think the authority has noted time and time again in both decisions, I think the term you used was muted. The effect of lower cost, lower debt service for a public-owned water utility, those effects are muted because ratepayers are stuck with the cost of this acquisition. Because Aquarion ratepayers, quote, will be paying through their monthly water bill the principal and interest on the acquisition premium. At the end of the day, there's no way out of this, okay? There's no way out of this. Based on your analysis and based on the models provided by the applicants, the number is $5.895 billion. That's simple math. 3.65 billion of that is interest. There's only one payer, the ratepayers, and that will take 40 years to pay off, at which time I will be 93 years old. That's when you will start seeing some cost savings. We can be sure about that. I want to also focus, as we talk about rates, on page 33 of the remand decision. You note that applicants project a rate increase of 6.5 to 8.5% from 2027 to 2035. This is utterly backbreaking for ratepayers. Let's do the math again. If you have a $100 monthly bill this year at 8.5% compounded, that's $208 in 2035, double in 9 years. These rates are not just, they are not reasonable, and they are not in the public interest. But the applicants say, don't worry, this won't cost the ratepayers a thing. In the motion to approve the offer of compromise at page 7, the applicants say current rate revenues are sufficient to cover 100% of the acquisition cost, and no post-closing rate increase will be driven by acquisition costs. At the motion to approve modified order of compromise at page 19, they double down. They say rates are sufficient to support AWA's payment of fair market value for the transaction without the need to ever raise rates. Ever. Those are their words. Commissioners, this is nonsense. With a straight face, they come here and tell you things that are not true. Now, to be fair, you didn't buy it, both in the first decision and on remand, but let's unpack their claim that ratepayers won't pay more than they already do. First of all, that's not true. I just mentioned that applicants are forecasting a 6.5 to 8.5% rate increase. But stop and think about this. They say they can cover 100% of $5.895 billion with current rate revenue. What? Are they saying there's so much headroom in their rates right now, in current rates, there's so much padding, so much fluff, that they can cover the entire $5.895 billion transaction cost without ever raising rates? Aquarion says, by the way, that if they don't get this deal, they're going to seek a rate increase of 28%. And if you ever get to that, I hope you'll remind them, they just said they have room in their rates for $5.895 billion. They don't need a rate increase. All of what they have said about rates is not credible. You can't trust it. And you know that. You said that in your opinion. You said, quote, there is a high degree of uncertainty about when and to what extent cost savings will be realized by AWA. As I said, there's actually no uncertainty. Cost savings might start when this deal is fully paid off 40 years from now. And as you said in your March 6th decision just 10 days ago, the payment structure raises an intergenerational inequity where today's Aquarion ratepayers will not receive the full benefits of the proposed transfer until a distant future date. How is that in the public interest? All of this was true on November 19th. All of this is still true. None of this has changed. So what has changed? We have the same record, no new evidence, no substantive proceedings since November. What happened in the intervening 3+ months that 3 of the 4 commissioners have changed your minds? If the answer is Judge Budzik and the Superior Court happened, I am here to tell you the court's decision changed nothing. Let me make that clear. The court's decision changed nothing. The court did not take Pura's power away. It bent over backwards in its decision to empower all of you to do your jobs. It said at page 3 of the opinion, quote, for clarity, the court does not order that Pura must approve the application. He went on to say, quote, it's inappropriate for the court to use its own authority to mandate approval. Again, quote, it is Pura's duty to make the difficult decisions involved in regulating Connecticut's public utilities, not the courts. With respect, Commissioner, the legislature is not the final arbiter on rates and on protecting ratepayers. You are. We delegated that authority to Pura, to all of you. Now, what he did say, as I said before, is that you can't quarrel with the structure. You can't quarrel with the membership of the board. You can't quarrel with the formula. You can't quarrel with the fact they use the OCA. You can't argue with the structure. Okay, fine. But he didn't stop there. He goes on to say at page 16 that even if all of that is true, he has to reconcile, he uses that word, reconcile what the legislature said with your general regulatory authority, which he says, quote, you retain. What he means is if you approve this transaction, this is what the RWA, AWA structure has to look like. You can't reject the application because you don't like the structure if you choose to approve it. But if you don't think the transaction is otherwise in the public interest, you can still reject it. You've said this before. You've said this before yourselves. In another case, it's a Con Edison case from 2000. There could be repugnant aspects of an application that could render a merger not in the public interest, even though the applicant itself might be suitable. So how does this work? Well, Judge Budzik says that you can't reject the transaction because the OCA is the only consumer advocate. But then he says you can reject it because you don't like the OCA's, quote, staffing level or, quote, budget or, quote, lack of independence. He says, quote, Judge Budzik, concerns raised by PURA with respect to the actual operation of the OCA are within the PURA's statutory authority and regulatory discretion. And the same has to be true about your concerns about the conflicts of interest, the fiduciary duties, the actual operation of the expanded authority board. You cannot object to how the board is structured, but you can say in your general regulatory authority, I don't like how it works. He closes his decision on page 18 by saying, the public interest is inherently a decision that should be made in the first instance by the responsible administrative agency here, PURA. The way you should read Judge Budzik's decision is that he says it is still your call. Judge Budzik told you as clear as day, if you want to approve, you got to do it the way the legislature said. But it's your duty to approve or disapprove. How do I know this is what Judge Budzik said and what he means? Well, as you know, the Attorney General provides formal legal opinions. I render that legal opinion on behalf of the state of Connecticut, and my office has done an extensive legal analysis of the court's decision and the law. And I am here to tell you, as a matter of law, it is my formal legal opinion that Judge Budzik's decision changed nothing. And whoever is telling you that, lawyer or not, is wrong. Now, I understand you may be feeling some pressure from the applicants because of all the...
Attorney General, please don't impute feelings to the commission. We are going to listen to everyone and take everyone under advisement, but I will say to everyone here, please don't impute feelings, opinions, or anything otherwise to anyone else sitting in this courtroom. It is something I don't feel is appropriate to do. Thank you very much,
Well, I
Attorney General.
appreciate that comment, Commissioner, and I apologize for the way I characterized my statement, and I retract it. But let me just say it this way then. To the extent that anybody would argue that that this commission needs to worry about applicants and Eversource, I submit that you don't. I have heard that Eversource may claim that they need this deal to cover their losses in other parts of their business. That's not your problem, and it is certainly not a public interest. I have also heard that Eversource says they need this deal to be healthy as a company and a functional utility here in Connecticut. And I just want to remind you, Eversource has plenty of money. Their stock price has gone up 19% in the past year. And again, that's not your problem. And it's definitely not a public interest. And the applicants act like they're doing us a favor by giving us this deal, that they're going to take a loss on it of $300 million. Please don't believe them. They want this deal. This is the best deal for them. Eversource's board of directors is duty bound to take the best deal for the company. If this deal is worse than other deals out there, they can't take it. That would be a breach of their fiduciary duties, and they could get sued. And I heard reference to another deal outside of this record by an investor-owned utility or some other buyer. And the claim that some other deal, some other transaction could be worse for ratepayers. Well, first of all, it's outside of the record. But I want to say, just stop. That is not relevant. They want this deal. We don't. In your first decision, you didn't. And if there's any future deal, they can bring it here and you will do your jobs to approve or disapprove. So I'm wrapping this up. What is this deal about? Well, it's about money, sure. But this transaction is about taking you, Pura, out of regulating water utilities in this state. The state of Connecticut has delegated the power to protect ratepayers to you. Why do you want to give it up? There is nothing in the law that requires you to give up regulatory power over Aquarion, but if you approve, you are choosing to give up that authority. I want to thank you for your patience, and let me conclude in this way. What if I told you the legislature wrote a new law? Here's how we're going to regulate electricity in this state. The electric distribution companies will now be in charge. There will be a split board. Eversource gets 6 votes, United Illuminating gets 5. For Eversource customers, there will be an Eversource RPB that sets rates. For UI customers, there will be a UI RPB that sets rates. But in any event, the companies have complete control of the process and the people. There will still be a consumer counsel, but they can hire or fire the consumer counsel at will. Claire will work 6 hours a week. She'll get paid $60,000 a year, maybe, if they approve their invoices, her invoices, and Pura is totally cut out of this equation. What would you think of a statute like that? That's what's happening here today, commissioners. There's companies and ratepayers, and if you approve, you put the companies in charge. Aquarion is a very good water utility, and we want to keep them. Everybody hates this deal. You hated it. Don't do it to us. Don't do it to the people of this state. Stand by your decision rejecting this deal. Don't serve the applicants and their financial interests. Serve us. Serve the public interest. Thank you. Happy to take questions.
Thank you, Attorney General, and thank you for making the time to join us today. I know you're a busy person, so we appreciate it. And this is an important deliberation. On your last point, I had a couple questions, but your last point almost implied, I hate to say this word out loud, but just among us friends, almost implies an antitrust consideration in terms of these are monopolies, so they're generally exempt from that.
Yeah.
But are you raising concerns about? It almost implied that there's that concern, but that generally doesn't apply to a public entity. So I guess I'm asking you to kind of ponder that.
Yeah, monopolies are monopolies, whether they're statutorily created or not. Actually, you'll find it humorous. What I did yesterday was I prepared for this argument, and I was working on the Live Nation Ticketmaster litigation, which is going to trial today, which is another huge antitrust case. And it is of no moment, frankly, whether it's a public-owned utility municipal utility, investor-owned, private equity-owned. If it's a monopoly, then it has market power, outsized market power. It is dominant, and it can use that power to hurt its competitors and ultimately consumers. And the feature of every monopoly is that we all end up paying for it. The feature of every monopoly, which is why we bring suit, is that we pay monopoly rents, RENTS. And that's what this $5.95 billion is. It's a monopoly rent that's going to be paid for by AWA customers.
Thanks. And I actually want to loop back to that too. But the reason why I raise it is because antitrust and economic regulation are considered substitutes in a way. And that's why, for example, you're pursuing your litigation that you just mentioned, because it's not subject to economic regulation. So then we rely on that alternative. But it sounds to me like, this relates to your point about the loss of PURA's authority going forward, and so that's an issue. So that's just more of a, if I'm understanding correctly.
Yeah.
Okay. So let's talk a little bit about the terms. Water, and it's interesting, that you mentioned learning about water mains and learning about the challenges that they have. Water is the most capital intensive of all the utilities. They have to invest, they have to have assets in the range of 5, 6, 7 to 1 to revenues, which puts them way, on a scale, way more capital intensive than others, even water and wastewater. So they need a lot of capital, and utilities generally, and water in particular, they sort of run on debt. They sort of have continuous I think of it as sort of rolling debt, right? That's normal. That's not abnormal. Debt is normal. And in fact, so we use debt to finance important things so we can meet environmental compliance and provide public health protection, all the other important things we need to do. And we also use that debt to spread costs over time to accomplish intergenerational equity. So I just want to be careful here not to about how we characterize debt. It'd be unusual and not necessarily a good thing to see a debt-free a public utility. Would you agree to that?
So let me just say, because you just referenced the intergenerational inequity in your question. And I remind you, you have found that notwithstanding the use of debt, that this creates an intergenerational inequity. So in fact, the use of debt here produces the result you don't want, right? Which is that ratepayers 40 years down the line will be paying all the way up until that point and may see cost savings at that time. Yes, I understand that debt may be used in any number of contexts, and you're more of an expert than I am, but I take you at your word that water utilities are more capital intensive and rely on a revolving cycle of debt. But debt is one thing. An unusual amount of debt undertaken by utility, RWA, that doesn't have the money. They just don't have it, which is why they have to borrow the whole thing, close to $6 billion that is paid for over 40 years, resulting in rate increases of 6.5 to 8.5% at least on ratepayers now is unusual. It's extraordinary. It's backbreaking, and it's wrong.
Okay, so just to kind of pursue this a little bit more, that debt, setting aside the premium issues and so on, but that debt is debt has tax advantages under every model,
Sure.
but public entities get some additional advantages in terms of lower cost debt relatively, and possibly even access to things like the WIFIA, which is water infrastructure, or I'll get it wrong, but WIFIA, it's a large EPA grant program that they may have access to. And so they're, again, we have to kind of look holistically at the cost of debt, access to maybe new forms of debt, and the issue of no longer paying return on equity and no longer paying for income taxes. I mean, and possibly among other things. So you would agree, we should be looking at that holistically. And I'm talking not just even at Pura,
Yeah.
but as a society, like just thinking about options for
Yes.
utilities and infrastructure.
Yes, Commissioner, I would submit you have already looked at it.
Okay.
And in your decision, in several places, you say that the effects of financial advantages for a public water utility that can borrow at lower rates, tax exempt, are muted, quote unquote, your words. And basically you said, okay, I hear you, but when you add it all up, it's still $6 billion. I don't mean to be flip, but there's a lot of misdirection here and a lot of trying to make this more complicated than it is. Sure, let's stack up all the numbers, plus, minus, you give here, you take away there, but no one can deny, and the applicants are not denying, that it's $6 billion and there's only one ratepayer. The successor ratepayers that come from Aquarion and are now part of the AWA structure, they're the ones holding the bag. And so that's why with respect, I don't think you should be persuaded by these arguments that, well, they're a public entity and therefore they can borrow less, they have to pay taxes. Doesn't matter. They still got to pay $6 billion. And they don't see any cost savings until, frankly, 93, God bless if I get 93. The ratepayers won't see any advantage until we're all gone. That is the very definition of an intergenerational inequity that is not just and not reasonable.
Thank you.
Thank you. Just a couple of questions, Attorney General. One, and I believe the term we used was mixed and not muted, but I have a legal question. I'm looking at the Special Act 24-1, Section 62. Insofar as the provisions of sections 34 to 65 inclusive of this act are inconsistent with the provisions of any other general statute, special act, or any municipal ordinance, the provisions of sections 34 to 65 inclusive shall be controlling.
Yes.
If that's the case, why is our decision inappropriate? If this indicates that this shall be the controlling statute.
As I explained to you, it shall control the structural aspects of the transaction. Nowhere does the statute say you have to approve the transaction. In fact, it says over and over again, upon approval by the Public Utilities Regulatory Authority. And as I explained earlier, Judge Budzik said that notwithstanding the fact that if you approve, it has to look a certain way, you can still disapprove because you don't like how it works, because it's not in the public interest, because the rates create an intergenerational inequity. The fact that, I mean, this is common legislative language, right? When we write a new statute, and if I may, when we all serve together, okay? If you write a new statute, you want to make sure that it's clear that this new language supersedes prior language. And you want to reduce the risk of ambiguity. And so they tried as best as they can not to be ambiguous. And what they said unambiguously is, if you approve this transaction, this is how it looks. If you decide to exercise your authority to approve, this is how you have to do it. But ultimately, you can choose to approve or disapprove, clear as day.
Commissioner Cheeseman, may I jump in for just a second?
Of course you may.
Thank you. So, on the issue of rates and just and reasonable rates, which is a principle we certainly aspire to, but in these change of control, situations, we have that obligation to the Aquarion customers right up to the moment of sale. And then all of a sudden things change, right, institutionally. We're sort of passing them along to other institutions, and other governance structures. So where does the authority find its role in judging just and reasonable rates the second after the sale?
It's your job, you use the word holistically, it's your job to assess this transaction on the record before you and its impact on ratepayers and whether it's in the public interest. I submit it is not your role to shadow box about what might happen under a different structure. Your job is to look at this structure. And under this structure, this is why it's so bad. Under this structure, you have a say here whether to approve or disapprove. And then the moment you say approve, you lose all your power. And the ratepayers all have to eat close to $6 billion. That's what's so wrong with this structure. Maybe if this structure said Pura stays in this, we'd be having a different conversation, but it doesn't say that. And so I think that this question about what happens to the point where AWA takes over Aquarion and you lose your jurisdiction is a bit of a red herring. You have to look at what's happening right now and what's in front of you.
Already broken the equipment. But where in statute do we have authority to condition the merger or affect the transaction price or other terms?
I would submit to you this. Under 16-22, you have the authority to make any decision you want, subject to the dictates of the legislature, to make sure that this transaction is in the public interest. And so if you decide that this transaction price is no good, you have the right to reject it. You could say, because there is a process of offering to compromise, you could signal to the applicants, why don't you cut your price in half and maybe we'll talk. You haven't done so. But at the end of the day, this idea that I don't agree with this characterization that you don't have the power and authority to change the transaction price. You do. The power is to say the price is zero. I disapprove it. Come back with a better deal. There's no reason, by the way, that you couldn't disapprove this application without prejudice and say, come back to me with a better deal and we'll look at it then. There's no reason you couldn't do that.
Thank you.
And obviously, I'm not an attorney general. But the idea that we as a quasi-judicial body, subject to ex parte communication, could go to the applicant and say, hey, let's talk about making a deal, is obviously not really going to happen, is it?
No, I could suggest to you that in rejecting this deal, you could spell out in your opinion what your objections are to this deal. You could signal to the parties your concerns, and these are smart people. They can figure out what you mean, and they can try to find a deal that does better. Judges do that all the time.
And I've asked this of the other applicants. Has the Office of the Attorney General engaged with either the legislature, the applicants, or the other parties to help mediate and come up with a better deal?
I'm not aware of any effort to mediate. We have spoken to the legislature. We did speak to the legislature about this statute, which, by the way, let me just point out. As you know, I spent 12 years in legislature. 4 years as chairman of the banking committee, 4 years as chairman of judiciary. I served with 2 of the 3 commissioners here today. We all know that this was an unusual statutory process, that this came in an e-cert, okay, without meaningful opportunity to comment. It did not go through the committee process. It did not happen over years and years and years. Frankly, I will tell you, the Attorney General's office, Our thought was, where'd this come from? Where'd this come from that it's suddenly on our plate? And so we scrambled, like everybody scrambled, who is opposed to this deal, to try to stop it and try to change it. We were not successful. But I submit to you that all of the questions or concerns about whether anybody did anything to affect the legislature or achieve a different result are frankly of no moment, because that is not in the record here today. What is in the record is this deal, $5.895 billion to be paid for by ratepayers, and it's your job to decide whether or not this deal is in the public interest. You have said over and over and over again, it is not in the public interest, and I encourage you to stick with that decision.
All right, another legal question
Sure.
for you, Attorney General. We've heard about the modified offer of compromise, and regardless of how it plays out, would it be, and we know that the authority is going to have to bond. Could a condition, a bond covenant be incorporating that modified offers of compromise?
I'm sorry, I don't quite understand your.
So, and again, we shared some time in the legislature. I know when Connecticut was borrowing and we put forward those fiscal guardrails, we included in our bond covenant that we would abide by those fiscal guardrails or have to pay back the bondholders. I mean, I don't write bonds. I'm not a lawyer.
Yeah.
Is that something one could include in a bond covenant
Let me respond.
as
this
far
way.
as enforceability is
Let me
concerned?
respond this way, and I thank you for the question. The most honest question, the most honest answer is I don't know. Okay, but I do know this. Number one, that's not before us today. That's not in this record. That's not what's being proposed. That's not what is before these commissioners. You have to approve or disapprove what is in the record right now. Number one. Number two is you would have to have a bond market willing to buy bonds with those conditions, and I think it is beyond speculative to assume that that could happen.
Absolutely, but there seem to be a lot of people here speculating, so I thought I'd just share in the
Why?
speculation.
I am encouraging this commission not to speculate. I am encouraging this commission to stick to what is in the record and what has been presented to all of you. I'm encouraging you to look at your own words and stick to what you already said. I'm expressly encouraging you not to speculate about what another deal looks like, about bond covenants, about what the legislature might or may not have said if I had talked to the speaker on X date. It's not relevant. The only thing that's relevant is the record in front of you.
Thank you.
I think we're all set.
Thank you.
Attorney General.
Thank you.
I think I have RWA next, then Eversource. Well, so I think just before you guys start, we're coming in on 3 hours for round one. So I think RWA, Eversource, I'm gonna suggest we take a lunch break in between rounds of a little longer than 20 minutes. So I'll just let everyone think on that. And we can circle back to it after the last few presentations if there are any objections to maybe like a 30-minute lunch break between rounds.
Very well. I think that makes sense from our perspective. So good afternoon, Dan Canavan on behalf of the South Central Connecticut Regional Water Authority and the Aquarion Water Authority. I will be joint presenting with Eversource, and Vincent Pace, Attorney Pace from Eversource is here as well. He's going to handle a number of topics, and I'll handle a number as
Your
well.
mic is a bit low. There you go. Thank you.
Is that better? How about now? How about now? Is it on? Robin, help me out here. You just have to be closer. All right, thank you. So it's not going to surprise anyone in this room that we think you got it right. We think the proposed final decision is the proper response to the issues raised in this case. And we would urge you to issue as a final decision without any material modification as scheduled on March 25th. Want to thank you for a fair, thorough, and well-reasoned decision approving the transaction. We believe as drafted, it is consistent with 1647 and 1622. It is consistent with Judge Budzik decision, and it's consistent with the enabling legislation. We've heard a lot of arguments today and in the brief, none of which are new. We've all heard these arguments before. None of them require you to modify your proposed final decision. And in fact, the Attorney General offered a number of arguments today that were also presented in front of Judge Budzik only a month ago. Judge Budzik rejected those arguments. There's no basis today, because they've been re-raised by the Attorney General's office, who represented PURA in the litigation, to modify the proposed final decision in accordance with those arguments. So we would ask you to resist any invitation to revisit those arguments now that have been previously foreclosed on appeal, that otherwise deviate from the well-reasoned proposed decision that reflects a lawful exercise of the agency's decision. RWA and Aquarion are great companies. They provided safe and reliable service for decades, and they will continue to do so if the transaction is approved under the authority model. No other transaction is going to match the ratepayer savings over time than the one that's in front of you now. This is a unique transaction. I mean, how many times will this authority review an investor-owned utility selling an operating company to an authority model? And the removal of the equity layer and the costs that are required to support an investor-owned utility are significantly overstated when you compare it to the authority model going forward. You've noted that in your decision, and you say on balance that the better deal for ratepayers is under the authority model. Now, we've heard a number of arguments about the OCA today. You know, if you look, the OCA is not the OCC. And if you compare the OCC to the OCA under the lens of the OCC, you end up in a strange place because they're not intended to be the same. First and foremost, the OCA, as the consumer advocate, as required by the enabling legislation, is embedded in the RWA process. It comments on the rate filing as they are being developed. The OCC doesn't do that. The OCC only sees rate cases periodically, comments them through briefing, through discovery in this room, through cross-examination. The OCA is in the room when those decisions are being made. The OCA is embedded in the capital planning process at the authority. The OCC is not in the conference rooms at the investor-owned utility, determining where those capital dollars are being spent. And therefore, when we get to an authority rate case that approves rates, the OCA's view and opinion is already baked in. And that in the OCC, you do not see that. You see them advocating for certain outcomes in this room, some of which are adopted by the authority, some which are not. So you could say, although it's different, the OCC is not the OCA, that the OCA may provide a better result for consumer advocates because it's embedded throughout the culture of the organization and throughout the development of those rate proceedings. We've also heard some discussion on the modified offer of compromise. The company or the AWA will live up to every element in the offer of compromise, some of which are enforceable by PURA prior to close, some of them which are in fact enforceable by the RPB after close, and then there's a certain number of them that are enforced by other state agencies like DPH and other agencies that are involved in water management. An important note here is that the towns have been arguing that once you approve this transaction and this company goes to an authority model that is unregulated. That's not true. That's simply not true. It's regulated through an authority model where the representative policy board made up of town representation will make decisions with regard to the ongoing capital spend in their districts.
Doesn't that model, excuse me, Attorney Canavan,
Yes.
doesn't that model actually reflect governance? It's sort of a combination of governance and regulation?
Well, I can see why you might say that, but the RPB, let's just remind everybody, the RPB, the Representative Policy Board, is made up of the representatives of the municipalities that AWA will serve. It is the economic regulator that will stand in the shoes of PURA during rate proceedings and capital planning process. So If a town does not want to conduct the investment in that municipality, they can vote those issues down. They have a say in what happens. They don't go into this black hole where the Aquarion Water Authority is running amok and making decisions without town representation. The towns are at the table, and that pales in comparison to what the towns have now. They are not at the Aquarion capital planning process. They are not involved in the utility, in the investor-owned utility running that utility. But under the authority model, they are integral to those decisions that happen at the RPB. So I just want to make sure that we're, when we say that there's no regulation, there's regulation. Is it different? Yes, it's different. But it's not a situation where this is an unregulated entity making decisions completely untethered from the municipal partners. Thank you. So with that, I think Attorney Pace is going to make a few notes and will be available for additional questions as they arise.
Good afternoon, Commissioners. For the record, it's Vincent Pace for Eversource Energy. And I want to thank you for following the law. I want to thank you for basing your decision based on the record evidence. I also want to thank you for recognizing that because this buyer is a quasi-municipal entity, they have no shareholders, they have a lower cost of debt, and they don't pay income taxes, this transaction yields the absolute lowest cost for customers. There is no lower cost transaction. The transaction presented to you is a once-in-a-lifetime opportunity to go from an investor-owned model to a quasi-municipal model. I want to first start with comments that were made about the cost to finance the transaction. And both the Consumer Counsel and the Attorney General say this is just simply too much. But in all due respect, that's not actually supported by the record. And you saw through that when the argument was raised the first time, and when it was re-raised again in your proposed final decision, you saw that their numbers simply don't add up. Their claim is it's simply too expensive to finance the transaction. But let's focus on the fact this is a one-time purchase price, and currently the record shows that Aquarion's rates are recovering the cost to finance the business. That's through a mix of higher cost equity and also debt. And that revenue stream and current rates will be used by the buyer to pay off the cost of finance. And this is no different than when you actually think about, for most of us, when we purchase a home and take a mortgage. Of course, when you pay that principal off over 30 years, it's going to cost more. But the more important question is, what's the actual interest rate you're going to be paying? What the record shows you in late file exhibit 30 is that the cost to finance that for an investor-owned utility, for example, is in the range of 6.5% to 7%, because you need that higher cost to attract equity investment. What the record also shows in that late file 30 is that the cost of debt for an entity like RWA is much, much lower, in the range of 3% to 4%. And the reason why that's important is when the Attorney General and OCC came up here and said, over a 30-year period, this transaction will cost the ratepayers $6 billion because you have to factor in the cost of interest. But he never talked about what would the higher cost be to finance the transaction if the buyer were an investor-owned utility. They're not discussing that number because the cost would have to be higher. And the reason why the cost would have to be higher is that you have to pay a higher amount for equity investors. You don't have the income-free tax benefits that RWA has, and you have a much lower cost of debt when you're RWA. That was not factored into the analysis, and so that's what a true accurate comparison would be. And Commissioner Beecher, I think you have a question.
Thank you, Attorney Pace. But would, in that scenario, though, if there were an acquisition something designated as an acquisition premium, wouldn't shareholders have to pick up that tab?
Well, I'm glad you raised the issue of the acquisition premium, and so I want to make a few points about that. First of all, your November 2025 decision didn't have an issue with the acquisition premium, but going to the acquisition premium issue, what's important to keep in mind here is that the acquisition premium, in this case, they've committed on the record and you've relied upon that commitment, and it's at page 28 of our August 22nd, 2025 brief, where they say rates will not increase at or after the closing to cover the acquisition cost. And in our brief that we submitted, we talk about two concerns that PURA has raised as it relates to the acquisition premium. I'd like to walk through both of those. The first is you've said the acquisition premium cannot be put into rate base when you've looked at prior acquisitions. But the concept of rate base does not exist in this transaction. Under the RWA AWA model, there is no such thing as rate base with an equity return for investors. So that first concern is satisfied because the buyer, if the transaction goes forward, will not have rate base. There will be no equity return on that rate base. The second concern that we've seen in your decisions when you've talked about the acquisition premium is that you say the buyer is not allowed to increase rates to cover that cost. And as I've said on page 28 of our August 22nd brief, we've said that the buyer will not be increasing rates to address the acquisition premium. That's because embedded within rates right now are funds to be able to cover the cost to finance the business with a combination of equity and with debt. I'd also point out too, that at least in the area involving the water business, your precedents also identify there are some situations where an acquisition premium can be recovered. And so, for example, in the context of distressed water companies, you've allowed for the recovery of the acquisition premium. We're not seeking to recover that here, but it points out you have in prior cases even concluded it was appropriate to do that. I'd also point out, and this is in the record, in your November 16th, 2007 decision and docket 0733, that involved the application by the Regional Water Authority in New Haven County to acquire the Ansonia division of the Birmingham Utility Company. And that decision, the authority had no concern about the acquisition premium. You never raised the issue regarding the acquisition premium.
Is it for Birmingham Water?
For Birmingham Water,
I
correct?
understand there was a negative acquisition adjustment in that case.
So that was for the other co-buyer, which was the Connecticut Water Company. So in that decision, there were actually two divisions that were being sold. The RWA purchased the Ansonia division of Birmingham, and the Connecticut Water Company sought to purchase and was given permission to acquire the other division of Birmingham. So for Connecticut Water, an investor-owned utility, you correctly point out there was a negative acquisition premium, and I believe that was allowed to be amortized over a 10-year period.
With refunds to customers.
With refunds to customers. But the key point here is when we look at your precedents, the concerns we see you raising are you're not allowed to increase rates to recover it, and you have a commitment from the buyer saying they will not do that in the record. And secondly, your concern was you've said you should not be allowed to put it in rate base and get a return. And that concept does not apply to the buyer in this case.
I'm starting to wonder, sometimes it comes out rate-based when we mean base rates. So I'm wondering about that, but we'll set that aside. Did Torrington, in the acquisition of it, Torrington Water, was there an acquisition premium?
I'd have to check with that Commissioner Beecher and circle back to you on that.
Okay, I don't believe there is. As long as we're on it, so there might be just differences in definitions here because as I'm gathering that you're using the term acquisition premium to mean the goodwill, the 100 million, and that that's been in many ways erased. I think it said in one of your communications by the change in value and investments that have occurred since the transaction was originally conceived. Does that sound right?
I agree with you. It's important to recognize that the acquisition premium, again, according to the authority, is going to be diminished by the fact that the New Hampshire and Massachusetts assets would be sold if the transaction is allowed to go forward. And in addition to that, due to the passage of time, the acquisition premium continues to shrink because as more time drags on, that value no longer exists.
Okay, I actually had questions about the New Hampshire and Massachusetts deals because I looked at their dockets last night and to see where they were, and they're waiting for us. But they indicate, let's see, that it adds up to about 100 million, 56 and 44 million for New Hampshire and Massachusetts respectively. your application says 150 million. And so you're going to get 100 from these out-of-state sales. And also, if I'm reading correctly, again, subject to check, and these things are all still in progress, they're not anticipating any premia in those two jurisdictions for those assets. But what happens to what happened to the other 50 million? Like, does that fall to Connecticut ratepayers then? In other words, if I'm doing the math, you had goodwill of 100, you had fair market value separately as 2623, and sometimes that's what's considered an acquisition premium as well. Then you've got intangible of 131, and then this out of state. So help us with the math here.
Yeah, thank you for the very good question. Because that's a computational question involving, reviewing calculations in the record, what I'd like to do, Commissioner Beecher, is if I have your permission to do so, at the break, I can speak to clients that are sitting in the audience, and we have some financial personnel here, and we can respond to your question on round two.
That would be great. Thank you so much. Let me just really quickly check, sorry, because I know I'm standing between us and lunch. Let's see. Okay, I think that covers my question about out of state. So I'm interested in that, yeah, and I'm interested in that breakdown of the premium. Okay, so the question has been raised by Attorney General Tong and others that is there some sort of offset going on between the potential economic benefits going forward under the public authority model? But is there some sort of offset because of any premium that might be embedded in the transaction? Your argument has been that, or the party's argument has been that that's not true, that there's no additional burden through rates, as you also just talked about recently. There's no additional burden to rates. But is there an opportunity cost? What economists would call an opportunity cost, because something happened and the ratepayers, or something could happen and the ratepayers won't reap the benefits of that. So that's called an opportunity cost, right? And does that apply here?
In our view, the most important focus from our position would be that ratepayers will benefit from this transaction because it is the lowest cost model available for the reasons we mentioned. No equity investors, lower cost of debt, and not subject to income tax. And there may be a difference in terminology in terms of how we're referring to what is comprised within the acquisition premium. But the key commitments I come back to are, you have a commitment from buyers saying they will not seek to recover the acquisition premium within rates, and there will be no equity return on the acquisition premium.
Okay, so you're raising a counterfactual argument, but one of those scenarios might be an investor-owned utility purchasing or coming to agreement with Aquarion, who would not be allowed to recover any fair market value or the full amounts of the premium that have been described. So in other words, that's another counterfactual, right?
And I would say it is important to take into consideration, when you look at the public interest, what the cost would be to ratepayers if there were to be another buyer. And again, the record shows this is the lowest cost opportunity. But the other key factor would be that we think the authority got it right in your decision, because you don't just devote one page to looking at the public interest. You go from pages 19 to 33, and you look at all of the relevant financial analysis, and you conclude, on balance, you say on balance because you did identify some concerns you have, but on balance, you conclude this transaction is in the public interest. And so we're not saying that you don't have any concerns. You have some concerns, but what you said is on balance. After weighing all of the record evidence, you conclude that the transaction clearly is in the public interest. And I believe if I turn to page 33 of your decision, after going through all the analysis, what you say is, AWA, which is the buyer, is expected to generate cost savings that lower customer rates through a lower cost of capital and other projected savings shown in the cost savings models. These factors ultimately support a finding that the applicants met their burden to demonstrate the proposed transfer is in the public interest. So that's where you talk about the fact that you have some misgivings, but the important thing is on balance, you say. On balance, when looking at all that detailed analysis, you conclude exercising your authority based on the record evidence, we have met our burden of proof to demonstrate this is in the public interest.
And how would you address Attorney General Tong's concern, if I may, and if I understand correctly, that this transaction might be viewed by some as wealth transfer from water ratepayers to Eversource shareholders in a way, because of the nature of the transaction as constituted?
There is no wealth transfer through a competitive RFP process. This was identified as the most suitable bidder. And just to remind the authority, after a lengthy process, you concluded that this transaction presented you with a buyer who had the requisite financial suitability and also the requisite technological suitability. The only concern, as was pointed out by other parties, was that you concluded there was a managerial issue, and they were for the reasons of board governance, for the voting structure, and the OCA. And as was talked about previously, in compliance with Judge Budzik's order, he pointed out, and the authority respects that order in your proposed final decision, you're not revisiting any concerns you previously had with the board structure or the voting structure. The only open issue that you looked at was actually two of them. The OCA, which Attorney Canavan explained, you had sufficient comfort that the OCA model is an appropriate model for this type of buyer. And then secondly, you talked about the public interest. And again, I want to emphasize that many parties came up here and said you gave short shrift to the public interest analysis. You did not. That's inconsistent with and not supported by the actual words that you used. You devoted substantial analysis on pages 19 to 33 to look at many, many elements that impact the public interest, and you concluded on balance this transaction meets the public interest. I'd also point out on pages 14 and 15 of your draft decision, you talk about the fact that you are correctly following Judge Budzik's decision. What you point out there is you recognize that Judge Budzik did not tie this agency's hands as it relates to your authority under General Statute 1647. You've exercised that authority here, and you concluded that we've met the criteria in that statute. What you also point out on page 15 of your decision is you say, Judge Budzik did not tie your hands as it relates to a public interest analysis. And that's why you have the very robust analysis that you do, and you concluded the transaction is in the public interest.
Thank you. Attorney Pace, I'd like to question you. A number of parties have referenced our inclusion of the modified offer of compromise and how this was inappropriate as they were not offered the ability to cross. And I'd like you to address that for me if you could.
Thank you for the opportunity to answer that claim, because you're correct. That claim was raised for the very first time in their written exceptions, and I want to make sure that we get the agency comfortable and your legal staff that there is no merit to those legal claims. So the first element that they point out is they state that, at least the OCC appears to state in their filing, that the offer of compromise is actually not in the record. So the offer of compromise was filed on October 1st, 2025 in the form of a motion, and it was modified in the form of another motion on October 16th, 2025 for the purpose of addressing concerns raised by the Consumer Counsel. And what's interesting to point out is General Statute 4-183G says that when the appeal was taken by the joint applicants, the agency had to certify to Judge Budzik the entire record. Well, Judge Budzik's record he received from this agency included the modified offer of compromise and the offer of compromise. And that was not objected to by the parties before Judge Budzik. So it clearly is part of the record. I'd also point out on page 7 of the town's brief, what they say is the MOC, which is the modified offer of compromise, was in the record before the issuance of the decision. But now going to the concern that was raised about due process. So the argument being raised is that because the offer of compromise and the modified offer of compromise were filed after the evidentiary record closed through motions on October 1st and October 16th, their claim is they were deprived of a statutory right to cross-examine, and they were deprived of the right of a hearing on that. And here's why that's legally incorrect. The first thing we have to look at is General Statute 16-19 JJB. And what that says is a settlement. It doesn't say an executed settlement agreement. It says a settlement may be proposed to the authority at least 3 weeks before the projected date for the issuance of the proposed final decision. And in your original schedule for this docket, the proposed final decision was expected to be issued 22 days later on October 22nd, 2025. So therefore, the statute allowed the joint applicants to file the offer of compromise pursuant to the authority in that statute. What's also very important about that statute, if you look at subsection D, it says, and I quote, PURA may hold hearings and may order briefs to be filed related to any proposed settlement. So it doesn't say you have to hold a hearing. It doesn't say that you're required to hold a hearing. It says you may hold a hearing.
Attorney Pace, is it appropriate to characterize an offer of compromise as a settlement? And you know, when I hear the words, it's sort of an offer. I'm not sure if it's a compromise, but I'm pretty sure it's not a settlement. And so, you know, it's interesting, and I think it's relevant to, you know, to show evolving thinking and, you know, possible solutions to problems. That's a good thing. But it sort of falls short of demonstrating even compromise, let alone settlement. That, you want to comment on that?
Be happy to comment on that. And so what I think is instructive here again is the legislature did not use the words settlement agreement or execute a document. It says may propose a settlement, and it leaves open what a settlement can be. And if we take a step back, what was the intent behind the offer of compromise? It was to say that we're hearing feedback from parties. We are making a good faith effort to respond to those concerns. And if we look at the modified offer of compromise, what did we do in that modified offer? We said we're hearing additional feedback from the Consumer Counsel. We're trying to, in good faith, to address their concerns. We're imposing additional commitments on the parties in an effort to try and meet them halfway or even go further than that, to try and address the concerns and present that to the authority. What I'd also note that I think is relevant to your analysis is pending before the legislature is House Bill 5473, and that lines 147 to 148. They're proposing to insert the word agreement after settlement. So if this statute was limited to only executed settlement agreements, there'd be no need for this bill to be submitted to the legislature to try and narrow the scope of it. The word says—
Let's avoid what's in front of the legislature, Attorney Pace, because there's a lot of things
Understood.
right now in front of the legislature that are not part of the record.
Understood,
Right.
Vice Chairman. And what I would also ask you to consider on this issue is that the OCC and other parties are relying upon General Statute 4-177, which is in the Uniform Administrative Procedure Act, to support their claim they're entitled to a hearing and cross-examination. But I would submit the more specific statute, the one in 1619 JJ, which applies to settlements submitted to the authority in a contested case, is controlling because it says you're not entitled to a hearing. That's at PURA's discretion. What I'd also ask you to consider too is the issue of waiver. And so if we look at just the citation I'll provide, the Connecticut Supreme Court's decision in 239 Connecticut 638, it says it is well settled that if a party fails to raise a procedural claim or fails to utilize a remedy available to them, that constitutes a waiver. So let's go back and look at actually what happened when we raised the offer of compromise. We filed the offer of compromise on October 1st. The Consumer Counsel files an objection on October 8th. But I read through every line in that objection. Nowhere in that objection do they say, we want a hearing. Nowhere in the objection do they say, we want the right to cross-examine. We then filed a modified offer of compromise on October 16th to respond to OCC's concerns. No objection was filed. And the authority's standard practice is, when a party files a motion, you have 7 days to respond. In response to both motions on the offer to compromise, There was no timely submitted objection by the Consumer Counsel saying they wanted a hearing or they wanted the right to be able to cross-examine. So what the case law shows is that if you sit on your rights and you don't raise them, that constitutes a waiver. We're now hearing they want to cross-examine. We're now hearing they want the right to have a hearing 6 months after we filed the modified offer compromise. So even if you disagree with my interpretation of 1619 JJ, an additional independent basis for relying upon the modified offer of compromise is they failed to timely assert their rights, and that constitutes a waiver. They know what the practice is. If you have an objection to a motion, you have to raise that within 7 days. They never raised it within 7 days, asking for a hearing or the right to cross-examine.
All right, that was very informative. So I believe it was Attorney McLeod raised the point that there were certain items in that modified offer of compromise that would seem to violate, for want of a better word, the original outline by the legislature of the governance structure. I'd like you to respond to that, please.
I'm not aware of any requirements in the modified offer of compromise that would be inconsistent with the Public Act 24-1. We put a lot of thought into developing that as a good faith effort to respond to concerns that we were hearing from participants in the process, but there was no provision that we're aware of that would be inconsistent with. We could offer to do more than the bare minimum required by the Act, and that's what we're doing here.
All right, sorry, I didn't mean to interrupt. If during, I suppose, the pendency of the conversion of Aquarion into a public authority, all capital projects exceeding 2 million should require approval. And I believe the legislation originally said 3.5 million, if I'm recalling correctly.
In this situation, what we have the buyer agreeing to do is to offer more than what's in the legislation. So
Simply because you're offering to do more that's in the legislation, you don't have to abide by the terms of the legislation?
that proposal abides by the legislation and offers additional protections to consumers. Because what it's saying is we're taking transactions of even a lower value. And so we're meeting the statutory requirement that anything involving the higher number would be submitted to that process, but we're actually providing an additional protection to consumers on top of that.
All right, and understanding we are only operating within the record, what is there within the record that would indicate, because if this transaction were to be approved, PURA lacks its authority to enforce it, the enforceability of any of the items in this modified offer of compromise?
Thank you. That's a very fair question. And I realize as an agency, what you want to make certain of is that if you approve the transaction, you understandably want comfort and certainty that the commitments will be honored. It's a very fair request. I'd like you to please consider the following points in evaluating that issue. If we look at the actual modified offer of compromise, it breaks out the commitments in terms of who would have the ability to enforce. So pages 7 through 8 of the modified offer of compromise lists commitments enforceable by PURA. Pages 8 through 10 of the modified offer of compromise list commitments enforceable by the AWA Representative Policy Board. And so remember, after the transaction, the Representative Policy Board, comprised of the towns, would have the ability to enforce the commitments listed on pages 8 through 10 of the modified offer of compromise. Pages 11 to 12 of the modified offer list commitments enforceable by the other regulatory authorities identified on those pages. I think it's also important to point out that the authority got it right, which is page 7 of your proposed final decision says, and I quote, "The commitments in the modified offer of compromise are a condition precedent to approval of the application." And on pages 38 through 40 of your proposed final decision, you incorporate those commitments as orders and you require compliance filings either before the closing or after the closing. I'd also point out too that with respect to the Representative Policy Board, again, these are the towns that comprise the Representative Policy Board, they can take action to enforce these commitments. They're the beneficiaries of these commitments, and if there were to be an issue, they can initiate a legal proceeding to ensure compliance with the commitments to which they're beneficiaries. We think that the authority got it right. The authority's legal team looked through the record. You looked at the modified offer of compromise, and on page 7 and pages 38 through 40, you built in sufficient safeguards to ensure that the commitments will be honored, and if they're not, there is a recourse that's available to either the authority or the representative policy board or to the other regulatory bodies that are listed on pages 11 through 12 of the modified offer of compromise.
Thank you.
In looking through my notes, I think that we've covered the majority of issues that were raised, and I'm happy to take any final questions from the commissioners before we break in between round 1 and round 2.
I think Commissioner Beecher has some questions for RWA, so.
Of course.
I think Attorney Canavan's back.
Thank you.
Yep.
Thank you. Again, I'll try to contain myself. But Attorney Canavan, the National Association of Water Companies was an active intervener in this case. Is that right?
I believe that did file to intervene, yes.
Yeah. And Aquarion's been a active and prominent member of that association. Is that correct?
I am not sure. As AWA, we don't own Aquarion quite yet, so
Okay.
I'm not sure. Perhaps an Eversource representative could
Okay.
characterize their involvement.
That's okay. I think we can probably stipulate to that. So maybe you won't be in the best position to answer this, and we could defer it till later, but I was just curious whether their active participation created a conflict for Aquarion because of the nature of the transfer of ownership. They obviously appropriately advocate for the investor-owned model because that's their constituency. But yeah, I don't know if anybody can address it, but I saw a bit of a conflict there because of the the strong position they took against this particular transaction. And the other thing I'll note that and so unfortunately they're not here. So I these questions would probably be more appropriate to their representation, but in their June filing, they warned of the danger of artificially low rates. And then August, like less than 60 days later, they argued that there was a significant unmitigated risk of higher rates. And we've talked a lot about rates today, so we're sort of getting, competing views about rates. And, so I just kind of wanted to highlight that. They also assert that AWA does not meet the financial, technological, and managerial suitability standards, but isn't that incongruent with Aquarion's longstanding presence in the investor-owned industry?
It may very well. I cannot speak on behalf of the ANWC
Yeah.
or Aquarion's involvement organizations such that I could comment on a conflict of interest. I'm happy to
Okay.
talk about it, and perhaps if there is a response that Aquarion would like to offer at the
Okay.
second round, I'd be happy to do that. We have talked a lot about rates. And I
Yeah.
think your questions earlier talk about how it's difficult to compare at face value rates between operating companies because they are based on the service territory, the cost of service. AWA, when they set rates in the future, will adopt a cost of service model as part of that rate making process. So we agree with you that you can't just compare investor-owned utility rates are X, RWA rates are Y, and therefore an imbalance will occur because we all know that's not true and that's not how rates are met. In fact, there are investor-owned utilities in Connecticut that have higher rates than RWA. It's all over the map.
Yeah, that's pretty typical of the industry. And let's see, and my last question then would be the AWA would follow the same policies, practices, methodologies of rate making under the what was sometimes referred to as the utility basis for rate making. Obviously, with some alterations in terms of the issues of cost of equity and income taxes, that would be a difference. But they would
Right.
we would anticipate them to continue to follow the utility basis of accounting and rate making as they currently do. Does that sound right?
One moment.
Okay.
Yes, and the reason why I paused is that the authority model does have a general bond resolution that they have to satisfy to make sure that money can be bonded and is available. But in essence, the rate-making process would be similar to what you just outlined.
I'm glad you noted that. Thank you so much. I think I'm done. Thank you.
Thank you.
Okay, that brings us to the end. Oh, okay, brings us to the end of round one. So let's take our lunch break. Let's come back at 2:05 if anyone object to a little bit longer break than usual for lunch. Okay, good. So let's come back at 2:05 and then for second round, just, we can go till about 5:15. It's kind of our limit. Just keep that in mind for everybody. Thanks. See you in half hour.
Stay until he talks. Come back, I get a flavor. No. Already went into two batteries, my backpack was low.
So what are you looking at?
Not mine. That is Bruce's. Still here. Where are we?
Yes.
Just wanted to make sure that
other one. Do you like these?
Yeah. Oh, no, these?
These are like chocolate, like the food flavors. There's mints down there. I'm gonna do a cough drop.
Okay, it's 2:05. We'll go back on the record and commence with round two. We'll go down the rebuttal round in the same order. OCC, Towns, COGS, AG, then the applicants. The second round is rebuttal round. We've heard everyone's, arguments and had engagement in the first round. So let's try to keep the second round to actual rebuttal to points made in the first round by differing parties. So thank you for that. And Counsel Coleman.
I think the mic's on now. Yes. All right, good afternoon. If you'll bear with me, I've got several notes I took throughout today. I will try to be responsive, so I'm just going to go through those. I first want to say I appreciate all of the really engaging questions from all three commissioners here. This is a critically important issue, and we're really appreciative that you're taking the time to hear all perspectives and dig into some of the trickier issues. In terms of questions that were asked, just to provide a little more information, first, I wanted to speak to your question, Commissioner Cheeseman, about legislative intent and whether Senator Fanfara's remarks were just one legislator's position. I do believe the legislative history shows that that wasn't just one legislator. There are comments from the House floor transcript as well that reflect similar sentiment. Representative Kavros DeGraw, who brought out the bill for the House, said, quote, "There is no guarantee whatsoever that they would in any way end up with a winning bid. It is just enabling for them to actually bid. Again, it's a charter change. It is nothing but a charter change, which is why we're here." So I did want to round out the record with that additional testimony, and I believe that legislative intent is instructive here to the extent that the commission is concerned that the legislature did not want to give PURA its full authority to evaluate the full transaction in the context of the full record and determine whether or not it would be in the public interest. The record, the legislative history is clear that they did. We found the question on section 62 of Public Act 24-1 interesting regarding whether or not the fact that it says that this statute, this public act shall be controlling over others had any indication of PURA's authority. Again, I think I briefly stated, but wanted to confirm that our read of that statute is that it absolutely does not impact PURA's authority. And we think Judge Budzik's decision also made clear that PURA's authority under section 1622 and 1647 remain. The Public Act specifically told PURA or said that PURA shall approve or deny the application. And within that statement comes inherent the authority's role to review this transaction within the guidelines of 1622 and 1647. I do have to respond to Attorney Pace's arguments with respect to the differences. Oh, I'm sorry. No, I believe it was Attorney Canavan. The differences between the OCA and the OCC. I think it's, I acknowledge this is really a question of an in-house counsel model or an independent consumer advocate office model. And I submit that our independent consumer advocate office model is highly effective. To say that a part-time attorney with no technical expertise could produce a better result than my team that has accountants, rate design experts, engineers, policy analysts, and we frequently retain outside experts to substantiate this is just quite frankly absurd. In terms of the financial arguments, I think there is a recognition that the difference between the applicants and our position is the impact of this one-time purchase cost. I think the applicants have framed it as a one-time purchase cost that is worth all of the longer-term savings. But we believe that the financial modeling has not shown that. It is, again, Aquarion ratepayers shouldering approximately $5.9 billion of acquisition debt and financing costs, including roughly $3.646 billion in interest. So, while this this may be appealing to those who are trying to obtain, I'm sorry, well, I'll just put it plainly. While Eversource might get a couple $100 million in cash from this transaction that delivers them a benefit, it's ratepayers that rely on these essential services that are going to be crushed by this long-term debt. And none of the purchase costs include the significant investments needed in our water infrastructure. We've talked about the critical importance of investments in water mains, whether to address PFAS contamination or ensuring that we're modernizing aging systems. I do think the Attorney General is absolutely correct to point out in the record that when you compare our RWA and Aquarion's investments, this was actually in response to an interrogatory that OCC issued, that Aquarion's service line and main replacements were more frequent than RWA's, yet RWA's rates have been more. So this does cause concern in terms of thinking about the effectiveness, the cost effectiveness, and future infrastructure investments. I think the difference here with transitioning from an investor-owned regulated entity to a public entity is that if this was going to still be a regulated entity, there would be conditions and assurances regarding work to ensure that water main lines and other investments are made, but that isn't the case here. Again, this is a situation where the authority is relinquishing its oversight over the entity, so it's really important to evaluate past practice to determine what is the likely outcome in the future. I think when Attorney Pace, when I was hearing him express his view that this was in fact the best deal for ratepayers, which we strongly disagree with, I think he was careful to say that this was, quote, the most suitable offer. And that's very different from saying it's the least expensive. Again, this may be the most suitable for Eversource because it promised them the most cash, but that's as far as it goes. And I'd encourage the authority to look at confidential filings to evaluate whether this truly was the lowest cost opportunity. I recognize that's one factor for the authority to evaluate, but it is an important one. And finally, with respect to the offer of compromise, I have a lot of respect for Attorney Pace, but I respectfully urge the authority to ignore the argument that just because a party presents a document with ideas to the authority, it somehow becomes a settlement and that 1619 JJ is triggered. That's clearly not the intent of the statute. Regardless of the fact that it doesn't say a settlement agreement, it says a settlement. And any common language definition of settlement means a meeting of the minds or a compromise or an agreement between parties. A settlement cannot be unilateral. That would wreak havoc here before the authority. If at any time during any contested case, a party could come say, we have an offer of compromise and you have to treat this as a settlement and pursue all of the process that's involved in with 1619 JJ. It's just, it would be an absurd result. So I think in brief, I won't retread ground here, but you've heard a lot of discussion today. You've heard from my office as the representative of Aquarion ratepayers, which also includes the municipalities who are uniformly in opposition to this transaction. You've heard from the state of Connecticut, from Attorney General Tong. You've heard from the towns and the COGs that there is universal opposition to this transaction. The authority has a strong interest in ensuring that this is in the public interest. And we urge the authority to revisit the record in this proceeding, which we believe falls short of the applicants meeting their burden. Remember, it was their burden to demonstrate that this is in the best interest of customers. And I think it's important to think about that through the lens of, would they be better off with this acquisition? And clearly, the record shows that they would not. So thank you. I appreciate the indulgence, and I am happy to take questions or let the next speaker come on board.
I think we're good.
Okay.
We're enough fumes up here too. Thank you so much, Counsel Coleman, for your presentation. Attorney Ball.
Thank you. I'll also try to be concise, and I'm going to just hit on a few points. I don't want to overlap too much with Attorney McLeod, so hopefully this will be efficient. As OCC just argued, the concept of OCA producing better results because they are somehow embedded in the process of rate making at RWA compared to OCC is a fairly outrageous comment to make, but we don't even, that's not really the issue before you. The issue before you is whether the OCA, as staffed, as it is with lack of independence and lack of budget, all the things you've already concluded, whether that is in the public interest. That's the question. And you've already answered it. You answered it in your November decision. You properly concluded the lack of staffing, budget, and independence of OCA created an absence of managerial suitability and a lack of public interest. Absolutely nothing has changed. We're in the exact same position today that we were in November. So it is extremely uncomfortable to think that PURA will now reverse itself when there has been no evidence or nothing in the record to justify backtracking on that aspect of the decision, which even Judge Budzik acknowledges is well within your power. The second point I will make deals with rates. So there was some commentary, Commissioner Cheeseman, I think you said, well, there's been a lot of speculation, and I agree we shouldn't be speculating, and certainly PURA should not be basing its decision on speculation. And that's what I want to highlight for you. There are known facts, and you've already reached the conclusion in the draft decision that we don't have to speculate about and that are in the record. So in the record, the applicants produced a spreadsheet. It was in response to OCC 42, attachment 1, and it showed the rate increases for the next 40 years. That's the applicants telling you that there will be rate increases. And not surprisingly, that's precisely what you concluded in the draft decision. So if I look at page 31, table 4 of the current draft decision that we are looking at, you see the projected rate increases that the applicants are telling you will happen. This is not speculation. This is the applicants admitting that from 2027 to 2065, these rate increases are going to happen. So there is a certainty as to rate increases. I want to juxtapose that against cost savings. You also concluded in your decision that potential cost savings are uncertain. In fact, they are speculative. And the discomfort that I think the Attorney General was highlighting deals with the intergenerational inequity that is exactly what the draft decision concludes on page 29. And that is the problem. We have a known fact, which is that for this generation, for everyone in this room, for my clients, and all of the residents of my clients, they are looking at guaranteed rate increases. The question for PURA is there an assurance of cost savings sufficient to deal with that? And even if so, will our generation, the generation that exists today, ever realize that? And the answer is no. The benefits to this, potential benefits of this transaction through the lower cost of capital are for a future generation. And you identified that in concluding, or at least in finding in the draft decision on page 29, that the dynamic results in an intergenerational inequity issue where today's Aquarion ratepayers will not receive the full benefits of the proposed transfer until a distant future date. And I do not take any issue with that. That goes to the heart of our discomfort with the financial suitability of this issue. So if you're talking about the public interest, which absolutely is what you need to look at, you are making conclusions that there will be rate increases for this generation, potential savings for a future generation. And I would submit to you that a transaction that is that speculative as to future benefits is not in the public interest.
Attorney Ball.
Yes.
So again, Aquarion is has a longstanding presence in the water industry, and it's hard to deny that they have technical, managerial, and financial capacity. I use the phrasing from elsewhere, but anyhow, and wouldn't you say that in the course of this transaction, the managers of both RWA and AWA would be strongly motivated to perform well, to contain rates, to demonstrate efficiencies, to demonstrate cost
I
savings?
certainly hope so.
I
would expect so.
Sure. I mean, because I think in the wake of this, and wake is the correct term, I would think they would be. And I would think that you would also be continuing to, should it go forward, that you would continue to be a watchdog, to continue to voice your concerns if you saw something that needed to be brought to the attention of the governing body. So I guess I just want to speak to or have you speak to the idea that there remains accountability, and perhaps even heightened accountability due to the spotlight that's on this transaction and on these entities going forward. They're really going to be, I think they're going to be, logically, they would be motivated to perform well. Would you agree with that?
I would put this in the category of sheer speculation respectfully. I think to conclude based on what we are looking at, that they're going to be so sheepish after the public outcry from this proceeding that they are going to take into account the concerns of local citizens when PURA is not there to regulate them, when they are essentially regulating themselves, contrary to what is being suggested by my opponents. I do not believe there is accountability.
Okay, but in some ways, PURA intervenes between the direct expression of democratic, preferences and values and local communities. So in other words, and you're all asking us to translate what's in the public interest. That's what we do here. So yeah, I mean, I just think I think there's trade-offs here in these models of governance and regulation and accountability, and we have to be a little bit reasonable in our thinking that it's not simple, simple apples and oranges. There's a lot of nuance here.
Yes, but here's the issue, if I may. When a rate application is brought before you, OCC has the ability as an independent consumer advocate to make arguments against, presumably, in the interest of consumers. And PURA has the latitude in your rate making to balance issues and take into account the applicant's needs, take into account consumer needs, and find that good middle that has worked well for Aquarion and the state of Connecticut for decades. And if I may, just to make my point, that latitude is gone under this model. Why? Because the way the rate making works is the expanded authority board governed by the RWA will make rate recommendations. At that point, those rate recommendations go to the representative policy board that has only two options by statute. It can approve or disapprove. It doesn't have the latitude, the regulatory latitude that you have now to find that sweet spot in the middle is gone. So we have a justifiable concern that when they tell us these rates are going up, they're not kidding.
I do agree with that point, and Counsel Coleman's point about the loss of the technical expertise that the regulatory model and the OCC model bring to this. I think those are valid points. However, you would also you would have legal remedies if you felt that somehow the interests of one of your towns was not being appropriately considered, wouldn't you?
Not necessarily. I mean, I believe that any private cause of action is doesn't kick in until there's a $3.5 million issue, I believe. And I'm sure one of my colleagues will correct me if I'm wrong. I think that's in the enabling legislation. So actually, the recourse to the courts is really not there. So let's assume a massive rate increase is proposed. Let's assume the representative policy board, even if there are some representatives from the towns, looks at it and says, well, geez, we can't make it zero. And, the system is going to break down if we don't approve something. So it's either all or nothing. We're, of course, going to approve all. And I believe that's the history in the RWA. The individual towns don't have recourse at that point. I don't have the ability to run into court and argue.
But
I certainly don't have PURA to
okay.
turn to.
But they're not exempt from constitutional and other statutory protections.
And I wasn't making a constitutional argument. I think within the Constitution, this structure gives unfettered power to the RWA and future AWA, if you were to approve this, to set rates. That's just a fact. That's the way this is set up. So it doesn't really go to a constitutional issue that would give me recourse if I'm a town that is harmed by a rate increase. It's a problem. That is a huge problem. I'm not saying there aren't long-term benefits potentially with the cost of capital, but we shouldn't be under an illusion that if we are unhappy with decision-making by the AWA, that there will be recourse because it's not contemplated.
Under existing statutory framework.
Yeah. Thank you. I'll just finish up with one other point. Oh, I'm sorry.
So to your point, one, that PURA somehow looks at what all the other interveners say and where we are or where the applicant says, and we just figure out a point in the middle. I just want to disabuse you of the notion. There are very strict rules that actually govern our rate making. And I know perhaps you were saying that somewhat flippantly. But we've had our knuckles rapped for coming up with decisions that aren't supported in the record and by very reasoned thinking.
Thank you. I just want to say that's not what I was suggesting. I was suggesting you have a latitude that does not exist under this structure.
Okay. And then you said going forward, because never in the history of RWA have they ever come down and in fact split the baby in terms of rates. What makes you think that's going to be the case going forward?
The way the statute reads is it's all or nothing. They do not have the latitude. This AWA representative policy.
No, I'm talking about the board working together. I mean, it sounded to me as though there was only, it's my way or the highway and where we don't go at all. Your reference was to AWA as opposed to their numbers and being able to overrule the members of the other pieces of the board. Maybe I'm being dim here.
I don't think you're being dim, but I don't think that's what I was arguing. The point that I was making is that there is no solace for the towns in the structure of the AWA Representative Policy Board as somehow being town advocates. That's not reality, because they have a duty, the Representative Policy Board, to say thumbs up or thumbs down without a middle ground. That's a problem. And what I'm making, the point I'm really making is we know rates will go up. They have told us, the draft decision concludes that, so these are not hypotheticals. That's a guarantee. The savings, long-term, in a future generation, maybe. That is far more speculative. And I would suggest to you that as we sit here today on this record, it is not in the public interest to approve.
All right.
that
I would be
uncertainty.
very surprised and would probably look dimly at an applicant who promised in perpetuity never to put the rates up, because I would have thought that was a totally irrational promise, but
Well, 2 points on that. One, these are huge rate increases. And again, I refer you to the table in your draft decision, in the HERA's draft decision, on page 31, table 4. You're talking about for the next, through 2040, rate increases ranging from 6% to 8.35%. And I encourage you to look at the dollar amounts that we're talking about in OCC 42 attachment 1. They're huge.
all right. Thank you.
Thank you. And I'll just make one final point, and then I'll be done, which is there is a disconnect between the arguments made by my opponents as to whether or not the acquisition premium is being passed on by virtue of this transaction or not. And there seems to be a little uncertainty as to what the acquisition premium is. So I want to highlight what the conclusions are in your draft decision. The excess purchase price is, I'm looking at page 24 and 25, and I think this is critical because there should not be any misunderstanding as to what ratepayers are being asked to pay. The excess purchase price over net plant of approximately $644 million, otherwise known as an acquisition premium. That's page 24. So the starting number is $644 million. I turn to page 25. You have a table that backs out certain items, including the adjustments include out-of-state properties, fair market value, workforce and reputational value. And on the bottom of 25, you come to your conclusion as to the acquisition premium. And you say, consequently, whether the acquisition premium is labeled as fair market value, workforce and reputational value, or goodwill is largely irrelevant. Aquarion ratepayers will be paying through their monthly water bill the principal and interest of the acquisition premium. Accordingly, only the $150 million adjustment for the out-of-state utility assets is appropriate, and you conclude, leaving a net acquisition premium of approximately $494 million. Not 100 million, not 50. 494 is your conclusion in this draft decision. Is it being passed on to ratepayers? I will answer my question because it's on page 25 in footnote 20. AWA will be financing the additional $494 million through debt, the cost of which will be borne entirely by Aquarion ratepayers because there are no shareholders. The acquisition premium, or whatever terminology we want to use, is being passed on. It explains why that chart that I referenced earlier with the big rate increases over the next number of decades is so high. We are paying for the acquisition premium, and I would suggest to you that is grounds alone to conclude this is not in the public interest. If there are no further
I
questions.
think we're good.
I'm done. Thank
very
you.
well. Cogs?
Good afternoon. Because the topic is still warm, let me see if I can paraphrase a little bit what I think the point was that Attorney Ball was making regarding latitude and the impact of rates. I would say, I would put it this way. When he says that AWA and in the past RWA have no latitude regarding rate increases. I believe he's referring to the fact that the legislation prescribes, obligates the RPB to either approve a rate request, or deny it. They have no authority under the legislation to modify it in any way. There is an underlying risk, given the fact that one of the main purposes, one of the requirements of a generalized bond resolution that governs the rate making really of both authorities is that they maintain their prescribed debt ratios, et cetera. That a lot of these rate increases are to satisfy the GBR, Generalized Bond Resolution. That puts pressure on the Representative Policy Board to say yes if you have the management team and the AWA or RWA board, as it may be, recommending to the Representative Policy Board that we need these rates in order to satisfy our bond covenants. So it is unlikely, witnessed by history, because it's never happened, that the RPB of AWA will ever reject a rate increase as being excessive. Instead, the pressure is on them to accept it in order to keep the bondholders happy and to make sure that there are no defaults on bond covenants. The contrast there is that when you come to PURA, as you know, if somebody comes in with, say, a 24% rate increase, PURA has the ability, and OCC will be on the case examining whether or not operations and investments have been prudent and efficient. And you have the ability to modify the amount. So if somebody comes in with a 24% rate increase, it is entirely possible that you will grant a rate increase, but only in the amount of, say, 13% or 9%, whatever. And it is that difference between the authority model, at least under the statute here, 24-1, and PURA, which introduces a great uncertainty about just how much the savings will be. You can bet, if history is a guide, and if the legislation doesn't change and allow any modification by the RPB, you can bet that whatever increase is requested of the RPB, it will grant in full, because it has no option but to reject it, in which case it puts the debt covenants at risk.
If I may, Attorney McLeod, why wouldn't an authorities board, any authorities board, have the same anxiety that PURA has every time we raise rates? You get the same, you get the headline, right?
I'm not sure I fully, I don't want to answer your question yet before I fully understand.
Yeah, what I'm trying to get to is two things. One is, why would a utility manager, public or private, again, let's say under ideal circumstances, right? I don't know what would motivate a utility manager to promote excessive, imprudent, wasteful spending that would lead to a like increase in rates. So that's the first issue. Why, I think there seems to be an underlying insinuation that the managers of these entities would surrender their sort of professional duty to run their organizations well, and then that they would not have sufficient oversight by their governing boards, because I think governing boards care about the headline, that rates are being raised, as well. So in other words, you know, it is, I think we have to be careful not to presume that there are no incentives here for discipline. Yes, they're different than they are under the investor-owned model with regulation, but it's not as if there are no incentives.
Commissioner, I don't think that's my point at all. I mean, I don't think, for example, if you take an investor-owned utility, and I'll take Aquarion as an example, I don't think that they have any incentive, because they are definitely cost of service regulated, but they certainly have no incentive to be inefficient. They have no incentive to incur headlines which are unfavorable. They have no incentive to come in here and annoy the regulator. None of those things. Nonetheless, history has shown that if they come in with a rate request, it is very unlikely that it will get granted in full. On the other hand, history has shown every rate increase in 45 years that has been put before the RWA Representative Policy Board has been granted in full. So it's not a reflection on whether or not the managers are incented or performing well or poorly. It's just the way the different rate models work. You have the ability to modify. Let's assume in your example that neither set of managers is incented to do poorly and that both are doing well. Nonetheless, a pure rate increase exercise generally results in some modification of the request in a downward direction. And that's not the case in the authority model.
So you're suggesting that economic regulation by the state provides an additional layer of incentives and accountability?
No, I'm saying purely as a matter of how the statute is worded, where it gives the Representative Policy Board only two choices. You can either accept and approve a rate increase in full as presented, or you can reject it as presented. You cannot modify it in any way.
And if that's not good public policy, isn't that something policymakers should take up?
Well, yes, but right now that's, the RPB is bound by that legislation.
Okay, thank you.
So following up on that,
Yes.
the Representative Policy Board turns down the rate increase. Surely it would then be incumbent upon the management to alter their suggestion and come back with an alternative. Would that not be a possible outcome?
Well, again, we get into, you would say in theory, yes, but in practice, that example has never been before us because there has never been a turn down of a rate increase by the RPB.
Well, although there are, to my understanding, more RWA people on the board than AWA people. I mean, are we not going to impute a certain amount of vigor to the new members of the Representative Policy Board in representing their municipalities and arguing the case if a rate increase did appear to be excessive, to attempt to persuade, as we are experiencing in this hearing room, that this would not be in best interest and to send it back to management? Again, we're talking speculation here, but if we're talking about past history, surely history does not necessarily have to repeat itself.
Well, no, it doesn't necessarily have to. I think everybody in this room, regardless of which side you're with, would say that if a rate increase is excessive, well, then the RPB will turn it down. In practice, I think given the pressure exerted by the fact that you have to keep the bondholders happy, you have to meet your debt covenants, your bond covenants, that when management comes in with a rate increase to the RPB and says this is necessary in order to meet our bond covenants, it's going to exert an awful lot of pressure on the RPB board to accept and approve the request, and the rates will go up.
Attorney
And-
McLeod, don't bond markets also consider managerial competence and operational efficiency? Isn't that something they would
No,
care about because it relates to risk?
I'm not the person to ask that question.
Okay,
I'm
no
not
problem.
Financial, I'm not in the bond market, so I can't.
Okay.
tell you that.
Okay.
But I think that the main thing they're concerned about is payments coming in. And maybe credit rating agencies are different. Bond markets, I'm not so sure.
Okay.
Um, There was I think, a question regarding recourse for enforcement. I'm not sure, Commissioner Cheeseman or Commissioner, yes. Can't you enforce these things, and aren't these commitments and promises good because you still retain the ability to enforce these after PURA is out of the picture and PURA jurisdiction is removed? Am I close to what you had asked? Maybe not.
I think I asked Attorney Pace because there had been the issue raised of were any of these enforceable post, PURA's removal as a regulatory authority, and he responded.
Mhm.
So
Okay, well, that reminds me, I may have a comment on his response. So if I may. The way I read that statute, the moment PURA approves, you no longer have jurisdiction. So if there's a waiting period between approval and closing, it may be that your order attaches conditions precedent to closing, but I don't know how you're going to enforce those because you don't have jurisdiction anymore. And one can only hope that they honor them, but enforcement is a question. On a broader point, I think that once PURA is out of the picture, then regardless of how these may be enforced, it's going to be a much more expensive proposition for the individual consumer to get any relief judicially than it would be to file a complaint with PURA and to get the kind of relief that you are very good at giving. And there's no longer any whip, if I may. I don't mean that in a bad way, but there's no longer any carrot, let me put that way, for the utility to make sure that they don't do something that's going to annoy you and come back to haunt them in their next rate case. And so that's gone. Now it's just a matter of, okay, this is going to go through the courts. And that's going to take a longer time, and it's going to be much less satisfactory if indeed any enforcement effort is successful. So that's the only point I wanted to make with respect to enforcement of these commitments. I think, we're discussing the mock. On the other hand, 1619 JJ, which Mr. Pace brought up, requires that whether it's a settlement agreement, or an offer and compromise, it requires that a settlement proposed to you be consistent with 1619E. You can't get to that point because the whole rate structure being proposed here is, as we have argued in our written exceptions and in our briefs, not consistent with 1619E 4 or 5. And so consequently, it's our position, and I'll rely on the briefs unless you have questions. It's our position that because the application basically does not comport with 1619E, then the mock is also disqualified. and you cannot consider it or adopt it. I wanted, there's a couple of other points. Attorney Pace argued that this is in the record. The mock is in the record, contrary to what the OCC and perhaps even Attorney Ball said. I tend to agree with Attorney Pace. These were submitted. They were submitted, get the dates, maybe October 8th, October 6th, I'm sure. At any rate, they were submitted and they were updated. As I mentioned in my earlier argument this morning, many of the commitments that are set forth in the mock are set forth in the briefs that were submitted, both the brief and the reply brief that were submitted to PURA before the November decision. They were also raised in oral argument. There was discussion of some of the mock commitments in oral argument. So they were before PURA when you issued your November 19th decision. Maybe it's 19th, your November decision. Since they were before PURA, and Mr. Pace apparently does not contest that they were in the record, they are subsumed by your decision, and they are considered to have been given whatever weight you thought was appropriate at the time. There's no requirement that you mention that you considered them in the November decision. That decision still disposed of those commitments at that time. Attorney Pace also said, and this is very interesting because I may have mentioned it in the written exceptions. If somebody sits on their rights and does not assert them, you waive them. That's essentially what Attorney Pace said. After the issuance of the November decision, there was no filing by the applicants for a motion for reconsideration based on an alleged failure by PURA to consider the mock or the commitments that were outlined in the brief that are also in the mock. When they filed their administrative appeal, they did not raise an alleged failure on PURA's part to consider the mock. This is all Johnny-come-lately stuff that is designed, as Attorney General Tong said, as a misdirection play to take your eye off the ball. And how the mock, after essentially they're ignoring it until now, assumes such an outsized influence in the draft decision is really questionable. And I think that if we continue this way, it just supports the record for another administrative appeal. I also want to bring out.
Question.
Yes.
So we're agreed this is in the record. I believe we're agreed that if someone doesn't do anything, you claim attorney says they waive their right to do it. So this is now Judge Budzik issues his decision. Well, surely if it is included in the record as we reconsider the decision, it is within our right to go back and look at the totality of that record, which includes the modified offer of compromise, is it not?
Well, two things on that. Again, you cannot, our position is that you cannot accept that because it does not comply with 1619 JJ's requirement that it be consistent with the principles of 1619E. So it's removed from your ability to accept by the terms of 1619 JJ. That's point number one. Point number two gets into the due process argument that was raised by the OCC. And this is what I said this morning. 1619 JJ does not necessarily require you to do anything if you don't wish to accept a mock, or if you don't, when I say mock, let's just say that that encompasses settlement as well. I don't want to bicker over terminology in that regard. But you are free to, because as Attorney Pace indicated, 1619 JJ uses the term may, not shall. So you can give it whatever treatment you want when it comes in. But if you are going to accept it, that's when the due process trigger gets pulled. Your decision to accept it and do something with it does trigger some due process rights on the part of people who would be affected by it, who haven't agreed with it and didn't even know it was coming.
So basically, you're agreeing with the argument of OCC.
Regarding due process, but I'm
Yes.
also agreeing with the argument of Attorney Pace that this has been in the record sufficiently to have been considered and considered disposed of.
It
in
was
your
considered
November
disposed
decision.
of because we didn't mention it in our original decision?
Well, you didn't adopt it, and you could have. It was briefed and argued, discussed at oral arguments.
But you and OCC are maintaining, because we then subsequently went back to it, that violates your due process rights because you didn't get a chance to
Yes.
brief or argue against the
That
incorporation.
would change the posture of the, and the impact of the mock on this case. And we were entitled to rely on your November 19th decision. And the fact that there was no protest from the applicants, either by way of a motion for reconsideration or in their administrative appeal, which claimed that you had committed error in your November 19th decision. They didn't raise it. They waived it. It's waived. Waived means it's gone.
All of this sounds like
and that's, I'm
all
taking
these
words
legal
out of his mouth.
arguments.
Hmm?
Yes, I'm sure the lawyers are all going to have very differing views of this, and I suspect we'll hear from the applicants when they are in their final comments. But thank you for your exposition of that.
Thank you. Last point I want to raise is that there was some discussion about, I think Attorney Pace indicated that as far as his legal team was concerned, there was no inconsistency between the offer in the mock to lower the RPB approval threshold from $3.5 million to $2 million. Well, that is specifically mentioned in section 53 of the of 24-1. Section 53 says the authority shall not, without the approval following a public hearing of the Representative Policy Board, approve any project in an amount more than 3.5 million. I'm not finding the exact words right there, but I do commend you to 50. I'm sorry, it's section 52. So that is in there, and you don't have the right, just because you're the applicant and you drafted the legislation and it was approved by the legislature, to modify the terms of that. We should all have learned that lesson in the course of the last administrative appeal and the decision rendered thereon. The legislature made a decision and specified, using the word shall, that 3.5 million was the threshold. And let's consider the relationship between the AWA board and the AWA Representative Policy Board, two different bodies. There's testimony in the underlying proceeding that the board does not report to the RPB. It has separate responsibilities. The things that it can do apart from RPB approval are specified. And it would be an incursion on the board's power to approve projects beyond what the legislature said was appropriate if the applicants arbitrarily changed what the legislature prescribed. There's a second dimension to that. And I think this may touch upon something that Attorney Ball was saying earlier. Section 63 of 24-1 says that any person who is aggrieved by a decision of the Aquarion Representative Policy Board with respect to any project costing more than $3.5 million is entitled to review by the Superior Court. The mock doesn't say anything about changing that threshold level. There's an inconsistency between the first provision, section 52, which establishes the threshold level of 3.5 million, and then the judicial review section, section 63, which also has the 3.5 million level. They can't change well, first of all, they can't change section 62 at all because it's mandatory legislation using the word shall. And if they were to do so, that would create a gap which deprived people of the opportunity to get judicial review for projects that were between 2 million and 3.5 million. Inconsistent, you can't do it against the public interest. I am at the end of my comments, but I would like to entertain any questions, and I would like to end with the request and the exhortation that you exercise your full statutory responsibility, which Judge Budzik's decision said was your duty to do. It's not an option, it's a duty to run this application through all of the change of control statutes that the PURA always applies when a change of control is proposed. That would be 1647D1, 1622 regarding the public interest, 1619E, and 1611. I don't see how you can, in light of all the things that have been presented today, find that these are in the public interest, given the acquisition premium issue, the burden imposed on AWA ratepayers alone at the so that RWA ratepayers can benefit, or any of the inclusion of the mock improperly in your draft decision. Are there any questions?
I think we're all set. Thank you,
Thank you.
Attorney McLeod.
Thank you very much for your time.
AG's office.
Good afternoon, Commissioners. We adopt and echo the arguments made by OCC. First, I will take a moment to address the modified offer of compromise. That cannot be considered for the reasons OCC has articulated in its written exceptions. It was never vetted or subject to cross-examination. That is a UAPA violation. We are not waiving this for appeal rights. But All of the comments regarding board structure and the modified offer of compromise are secondary to the cost of this acquisition. The largest, most devastating issue with this transaction is the enormous, unaffordable dollar figure in the acquisition premium. Putting the acquisition premium on ratepayers in this transaction is not in the public interest. We disagree with Eversource's contention that there will be no additional burden through rates with the acquisition costs. $5.895 billion in senior and subordinate acquisition bonds over 40 years. AWA will have to raise the rates of ratepayers to pay this. We know this. Those rate increases were demonstrated by the companies. First in OCC 42, Attachment 1. Second in late filed Exhibit 2, Attachment 2 in the Debt Services tab. You agreed that there will be a burden to ratepayers through this acquisition premium, and you said in your decision at page 28, the remand decision, despite the applicant's claim that customer rates will not increase as a result of the acquisition premium, there is no other monetary source by which to fund this portion of the transaction price. As a result, the benefits of a lower cost of capital for AWA are muted for the term over which the acquisition premium is financed and reflected in customer rates. This dynamic results in an intergenerational inequality issue where today's Aquarion ratepayers will not receive the full benefits of the proposed transfer until a distant future date. This is coming at a pivotal time when AWA will need to be paying to invest in its pipes, PFAS remediation, and other rising costs that do not include paying an acquisition premium with interest for the benefit of Eversource. The state, the Consumer Counsel, and the people proposed under the structure that it is set to represent are here today to tell you that they hate this deal, that the applicants have not met their burden under 1622 to demonstrate that this transaction is in the public interest, that the managerial prong of 1647 is not satisfied with the OCA as proposed. What else do you need? Who else do you need to hear from? We strongly urge Pura to reject this transaction and tell Eversource to come back and do better. I welcome any questions.
Thank you, Attorney General's Office.
Thank you.
Our WA?
So consistent with the joint presentation format we're taking, I'm going to start and first I want to thank you for the very good questions the commissioners asked during round one. We appreciate that and helping you deliberate as you move towards your final decision. Out of respect for your time, I will not restate any points that were previously made and re-argued, but I will respond to some very important questions that were raised. And I first want to start with a question Commissioner Beecher raised me, and thank you for the question. You had asked me on page 25 of the proposed final decision in Table 1, what was the actual amount to be received if the transaction goes forward and the New Hampshire and Massachusetts entities are transferred to Unitil? And after looking at the record, it appears in data response Q, COG 29 of footnote 1, the amount to be received for the Massachusetts and New Hampshire affiliates would be $100 million. So that number would need to be adjusted in the table on page 25 of the proposed final decision. The second point that
Excuse me, so are you saying the total price would be adjusted downward by 50, or would the total price of the transaction stay the same?
So the key point would be that in footnote 1 of the data response I referred to, it makes clear that from the disposition of the New Hampshire and Massachusetts affiliates, the funds coming in will be $100 million. And then right now, on page 25, the table shows $150 million. So that number would need to be adjusted. Can I have 1 moment, please? Thank you. Thank you for that moment to consult with our team. And the answer is the 2.4 that's shown on the table is a rounding. It's actually 2.3 and change, but it's been rounded up for the purpose of illustration in this table. So we can provide you with the precise number of 2.3 and change that appears in the record, and I can ask maybe one of my colleagues to provide that precise number if you need that detail.
Okay, then we'd still have to come up with the difference, right? Because we're trying to get from 644 to 2.3 something. So I guess I'm still kind of trying to understand how the difference is made up if the purchase price is not adjusted.
Again, in speaking with our team just a moment ago, their conclusion is that the 2.4 again has been rounded. And what I can ask is that once I get through one other issue, I'm going to ask Attorney Kimball to come up to respond to some other financial questions he would raise. So I'd ask for permission that when Attorney Kimball approaches, she can respond to that question, as well as responding to another question that you had raised regarding the acquisition premium. So we want to make sure we do a thorough job of responding to your good questions. So we will have her respond to that question also. The final point that I did want to make was in the second round, you received a number of comments on the modified offer of compromise. We first had Attorney Coleman on behalf of the OCC discuss the issue, and Attorney McLeod discuss the issue. And I think the important thing we'd like you to keep in mind would be Judge Budzik, as you correctly pointed out, said that it is in your prerogative to look at what is in the public interest on remand, and you've done that. Now, the attorney for the Cogs, Attorney McLeod, says, because you didn't talk about in great detail the modified offer of compromise in your original final decision back in November, he says, and I quote, "It's been disposed of." That's incorrect. It still exists in the record as a piece of evidence. You have the prerogative and the authority in this remand proceeding to take that into consideration and to credit it in the way that you have in your draft decision. So it's not been expunged or disposed of. It continues to exist as a piece of evidence in the record, and you have the prerogative as an agency to elect to credit that information and to rely upon that in reaching your conclusion, which we hope you'll move forward to rely upon that. It's also important to point out, Attorney Coleman said that it continues to be a violation of due process. And what she said was, you can't rely upon General Statute 1619 JJ because in her view, an offer of compromise is not a settlement. I offered my response to that, but if you disagree, if your legal team concludes an offer of compromise is not a settlement within the meaning of 1619 JJ, I want to remind the agency that an independent and alternative basis to allow you to dismiss their due process claim is that they've waived the right to request a hearing and they've waived the right to ask for cross-examination because your rules are very clear. When a motion is filed, a party has 7 days to request specific rights. In that 7-day period, when the motion was submitted, they never asked for a hearing, they never asked for cross-examination. And so therefore, you have a sufficient record to demonstrate there's been a waiver of any claimed right they believe they may have to cross-examine or for a hearing as it relates to the modified offer of compromise. Now, at this time, unless you have any questions for me, I'd like to turn the podium over to my colleague, Attorney Kimball, who I'd like to respond to a number of economic and acquisition premium questions Attorney Beecher had raised with me on round one, and she'll also respond to the question you asked about the table on page 25 of the proposed final decision. So thank you.
Hi, I guess I really want to respond to what parties have just said before we finish up today. And I wasn't planning on speaking, so what comes out of my mouth is a little unpredictable. So I have to apologize ahead of time to everybody in the room. I'd like to start, though, with this MOC, this MOC, or whatever we're calling it. To me, as an administrative lawyer who's been through a bunch of these proceedings over the years, that is a complete red herring. A commission always has the authority to set conditions on a transaction. I don't know why there might be some thinking here that you can't impose conditions. I remember at the oral argument we had in September, The former chair said something about this having to be an up or down vote, that there was that Pura had no power to set conditions. In these types of transactions, because you are looking out for the public interest more generally than just the standard, there's always room for the commission to impose conditions. Those conditions have to be in concert with law. You can't impose by condition things that you could not impose in your own jurisdiction of being the Pura commission. They have to be reasonable, or if they're unreasonable, they can't be fulfilled by the parties. But there's nothing that keeps the commission from adopting reasonable conditions that protect the public interest, protect the interests of customers. So whether or not the MOC is, the whole purpose of that was to try to put on the table, try to address other parties' concerns, and try to put stuff on the table that Pura could work with. You don't have to adopt the MOC. You can adopt your own conditions. And that's always going to be within your purview as long as it's within the evidentiary basis of what you've learned and it's within the law in which you operate. So I'll just say that first. Second, if we look at that chart that Commissioner Beecher, that you are looking at on page 25, there is a mistake there, and it's just rounding. So if we look at that and just redo the chart a little bit, the transaction price is really $2,350,000,000. So if you start with that and subtract the Aquarion net plant that you have here, you end up with, I'm not good at math, but 594 maybe instead of 644. And then when you subtract $100 million instead of the 150, because that 150 is wrong, then you have minus the 263 you come up to 493, which is just about $100 million off. And that's the acquisition premium, the 100 million. Does that make sense?
I'm sorry, I heard 100 twice, so I want to go back. And I think the 150 came from your original filing, right? And it was never corrected.
It's a correction that should be made.
It should be made now.
Correct.
I got it. Okay,
Yes, so if you change that to 100, you get to the goodwill of 100. So there's no 150 there. That should be 100.
But it was 100, there was 100 in goodwill already.
Yes, but I think your question was, I thought you had asked, I'm sorry if I misunderstand you, I thought you had asked that you thought there was 150 million of goodwill out there.
No, I understood that
Okay.
there was 100. Thank you.
Okay, no, sorry, okay.
I guess let's try it another way, because if the terms of the transaction or the terms of the financing involve cash plus bonds, right?
Mhm.
And you're not going to get as much cash out of our neighbors.
Yeah,
They're ratepayers. So where do you get the 50 million from now?
well, I thought that's what we were answering, but the transaction price is not 2.4 billion. It's only 2.350 billion. So the transaction price here is a little overstated because it's rounded up.
Okay, so we're accounting for that then.
Yes,
Okay.
yes, okay.
I did
And-
want to know that.
And we also used, throughout the transaction, we also used the figure 2.4. That it was just a rounded figure that everybody used, but the actual price was actually only 2.350. So it's just rounding. Okay? Okay, then I'd like to address the Consumer Counsel's statement that this is not the least expensive transaction for customers, and try to get into just very quickly to some of the math here, because this is the least expensive transaction for customers by far. And I just want to start with, it's actually very unusual that as a regulated utility, it's very uncomfortable to be here saying, oh, let's do this transaction because it's better for customers because they're not going to pay an equity return, right? They're not going to pay these things that we come in and beg for every case. And guess what? They're not going to have to do that over there. And so this is so much better for customers. And when I first heard that this is the transaction that I was going to be asked to bring for approval, I exactly had the reaction. Nobody's going to understand it. Nobody's going to like this. Nobody's going to like, it's uncomfortable to change the model. It never happens. It just never happens because it's very unusual. But circumstances in Connecticut have been very unusual. And the set of circumstances that happened in Connecticut led to a situation where this ended up being the buyer that came forward that could do the transaction, and they actually have a huge benefit that you never see when you get to come in and sell a transaction, which is you're coming in with significant savings by costs that nobody is challenging are coming out of the cost of service. It can't be challenged. Those costs are coming out. And so then the whole dialogue kind of comes back to this acquisition price. And is somehow this entity paying more than it should, or more than anybody else, or more than customers can afford? And all of this is no. And I think you asked such a good question earlier. Is there a wealth transfer going on? Certainly, Eversource is selling the asset, just like I might sell my second car if I couldn't pay 2 car payments. How do you fix your finances? You might sell an asset that you just can't afford anymore. And so certainly there's going to be some benefit to Eversource to sell the asset. Otherwise, they wouldn't be selling it. They love this asset, but they have to sell it. And so, but does that mean that when they sell it to AWA customers, there's some kind of wealth transfer? I would say it's the other way around. The wealth transfer is going to customers in this unique circumstance, because at the time Eversource decided to sell, the situation here in Connecticut with regulatory was so bad, it was difficult to attract a robust field of purchasers. So the price is lower than it would have otherwise been. And they actually had to write it down, as I think even the Attorney General office recognized earlier. They had to write their asset down by $300 million.
Say that's what's reported in your 10K, it's about 300 million.
Right.
Yeah.
So they're selling it for less than they had on their books. So what was that value, the 2.7? That is the value they have on their books after buying Aquarion in 2017 and paying an acquisition premium, which they did.
Okay, but is that the responsibility of ratepayers? And those were business decisions.
Right, absolutely.
And
Sorry, go ahead.
and utilities operate in an environment that still maintains a certain amount of business and financial risk. So like say I bought a car and I didn't make the greatest decision. This is a true story.
Yeah.
And boy, it depreciates like
Right.
way faster than I had planned, right?
Right.
Do I go back to the dealer and say, or who do I go to but me to take responsibility for the decision that I made?
100%, but and you're absolutely putting your finger on, that's the harm. That's their problem. They've lost some money on it. That's their problem. They had to decide to sell it at that moment. So that's their problem. Nobody's bearing that.
Okay.
So my point is that that the AWA customers are lucking out in a way, because something is more affordable than it would have been at another time. And so the price is lower than it would be at another time, because if I was a buyer, a utility buyer is going to come in just like Eversource did when it paid 2.7, including an acquisition premium. It booked those amounts, right, on its books. It booked an acquisition premium, and all it can ever do, because it can't get an acquisition premium through rates, right? We don't allow that anywhere. So all it can do is rely on the stream of revenues from the business.
Okay, but this isn't a free market transaction.
Right.
There are experts, as you know, because they've been involved in this, I'm no doubt. They come in and they do a valuation study. They look at, rates and revenue streams. They look at all these variables. And they look at whether there would be, for example, any intangible amounts that could be valued. So it isn't as if, it is not as if you would have a lot of headroom there. I mean, for one thing, the market for buyers and sellers in the investor and water industry has really consolidated. And, I think they're after Torrington, I think it's like 8, counting Eversource, 8 or 9 are publicly traded. So it's a really, really consolidated field now. And I know you know that. So yeah, I'm not sure the idea that there would be like, that's another hypothetical, I
Okay,
guess.
that's
And
fine.
we're going to say what
I-
Judge Budzik wisely said, which is we can't deal with
And
hypotheticals.
I'm not trying to, that was a point on to another point,
Okay.
which is whenever any buyer comes in, even if we were buying a family restaurant, we're looking at the revenues that the business generates to figure out how much to pay, right? We can agree with that. So we look at those revenues. So when a utility buyer comes in, they're looking at the revenues, current revenues, and then what kind of rate cases can we have? What kind of rate? And they're going to run their models.
Right.
And AWA did a similar thing. They come in and say, just like any other buyer, they're just like any other buyer. They come in and say, okay, there's a $2 billion investment plan over the next 10 years, same as Aquarion has. What's that gonna look like for us to do that plan? And in addition to paying for the purchase price. So when we look at and they decide, they figure out with their models that current rates, just like a utility buyer, current rates are sufficient to cover the price that they bid. Nobody is going to bid more than what they think the rates can support.
Okay, and this price is about 1.7 times book. It was at one point. I don't know if that's current. Does that sound like in the ballpark? Sound in the ballpark? Okay. Not going to hold you to it. Don't worry about it. Okay.
My financial consultant is saying times rate base.
I'm sorry. I meant
Yeah.
to say, and thank you. Thank you. I meant to say that. So if you're a seller and you're evaluating in the field and one transaction has constraints on it in terms of something like a fair market value adjustment, and another transaction lacks that constraint, is that going to tip you a little more in favor? Or is this something that factored into?
Just to make sure I get your question right, are you saying that the seller might look and say, here's a buyer that is paying a price and they won't be allowed to get their fair market value in rates, but here's a buyer who they will be able to get their fair market value in rates?
Correct. And because buyer one in your scenario has to go to their board and their investors and say, you need to pick up the tab for this.
Yeah.
We think it's worth it, but it's a different calculus when you can allocate the cost one way or the other.
There's always going to be qualitative factors that the utilities take into effect when they're deciding among, like, who do I want to sell to? And obviously, they're always looking to try to mitigate risk, right? They're always trying to figure out which transaction would have the least risk. And so we can think about, but in terms of whether fair market value is going into rates, I don't think there would be any differentiation, because if you think about the current rates, just think about this number for a minute. The current rates right now are generating $230 million a year. So if current rates never changed, and we heard from the Attorney General this giant number, this great big problem, which is this $5.895 billion and that they'll have to raise rates. We know that they're going to have to raise rates. If you do the math of 40 years at $230 million, that comes out to $9.2 billion over 40 years. So rates are already generating. So when I'm the seller and I'm looking at the buyer, a risky buyer is going to be one who's overpaying, right? Because how are they going to make it work? How are they going to make their number work?
I'm sorry, the 230 million, is that
Those are
Total
the,
operating and capital?
those are total, yes, total operating revenues, including capital recovery.
Okay.
And we just filed a rate case that would raise that to 300 million if we got approved. Now, nobody expects to get approved at what you file, but if you did the math on that, that would produce $12 billion over 40 years. So customers are paying this $6 billion number that he is extracted from a model that we put into Discovery that is the interest cost if it takes 40 years to pay off the loan. Just like if you went and got a mortgage on your house, you borrow 500,000 and you take the 30 years, they give you a truth in lending statement and they say, oh, you're going to pay back. It's always shocking, right? You're going to pay back like 850,000 instead of 500,000 because you got to pay interest on all that money that you're going to borrow and not pay back for 30 years. So this $6 billion number is the cost of the interest if it takes 40 years to pay it off. But rates, if nothing else happened, not another dollar was spent, not another rate increase happened, 230 million a year right now they're generating, that's 9.2 billion. Nobody's rates are getting raised to pay this interest. The interest belongs, it's rationalized to the 2.4. It's borrowing that 2.4 at a fairly low rate because they can do, RWA can do that at a low rate. If the buyer had been a utility buyer, they would have been doing the same financing, $2.4 billion. They would have been using equity at a much higher cost. They would have been using more expensive debt. They would probably be looking, their cost of paying back over 40 years, I don't have the math. I think my colleague Vincent, Mr. Pace brought this up. The math, it would be exponentially higher over the next 40 years if this was a utility buyer using their debt and equity. This is the least expensive transaction for customers. And I just want to say one more thing, because I don't want to hear it one more time. Intergenerational suffering or whatever it is. We have filed a rate increase with PURA for, I forget the exact amount, 75 million. I don't know what will be the end result of that, but it'll be some increase. So, but if you look at, if this transaction were to go through, the first rate increase, and this is on the record, that customers will experience, the cost of that is projected at 18 million, and it will only be to cover the incremental cost of operating the business and the capital investment from the point of the sale forward. And that we know is going to be cheaper because it's not going to have any federal taxes in it. It's not going to have equity in it. We know that in that first rate increase, today's customers are going to realize the benefit of the lower costs and the lower rate change because there's just costs missing from the cost of service. Meanwhile, they're not paying anything more because the transaction closed, because the rates they were already paying were giving Eversource money to pay back what it borrowed and what it took from investors when it bought Aquarion. And so Eversource will take the proceeds of the sale, pay off their investors, pay off their debt lenders, and it gets refinanced. Just like a house, it's refinanced. So customers are not going to be harmed. There's not any intergenerational inequity, that there's no benefit that's coming 40 years down the road. I think the record is that there's an optimization plan that RWA has come up with that, like any homeowner that wants to kind of get ahead of the mortgage, they're planning on trying to, once they pay down some, use those revenues already available through existing rates to pay ahead and reduce that total cost. And their plan would be to not pay that $6 billion, but to pay some lower costs because they haven't had the debt stay out 40 years. That's all in the record.
Okay, just to, intergenerational equity is a real thing. You know, it's a real, it's a thing
Agreed.
we care about. And
Great.
And we care about, you know, when we think about just and reasonable rates. It really
Absolutely.
relates to that. I'm still a little hung up on my 50 million. I apologize.
Okay, no, and I'm not good at math.
No, that's okay. You know, who wants to do math on the fly, right?
Can I phone a friend on the math?
Absolutely,
Okay, thank you.
absolutely. So, what I'm trying to understand is whether, that 50 million that we were, hoping to come in to the transaction, do we make that up by either cutting the goodwill which would mean cutting the transaction price, or do we have to go to the bond markets and get 50 million more?
The transaction price is actually 50 million lower than what's in the table. So if you change that and the 150 to 100, you get to the same 100 goodwill on the bottom line.
Okay, so you're adjusting. All right, I'll check it out. Let's.
Yeah, so the first line and the fourth line will each be reduced by 50. So the bottom line net change is 0.
The goodwill?
Yeah, the goodwill is still 100. The out-of-state properties goes from 150 to 100.
Right.
And the transaction price goes from 2400 to 3500.
So you don't have to. So if we were like looking at the bond, so now let's go, but the bonds add up, the bonds and the cash add up to 2,400 though still, right? So what are the numbers for the bonds and the cash? I'm looking at the other side of the, transaction now. Yeah.
So you're looking at the Eversource numbers that we've kind of bandied about, which are the $1.6 billion in that.
Right.
Okay, so I think but you answer,
Well, I believe it's the same rounding. I think we've just been using.
Okay.
4 billion, 1.6 of equity and 800 million of debt as our
Okay.
estimates to get to the 2.
Which one, like, rounding, we're rounding some really big numbers here. So, so let's, I'd like some clarity. And if it takes a minute, that's fine. We can talk about other stuff and, about whether this factors into the debt financing or the cash part, because I assume the debt, could be affected.
Yeah, so the reason we've been rounding and using those as estimates is the final price will be trued up at the closing date based on the actual debt outstanding. So this is what the amount of debt is. It was either at the time of the transaction or the projection at closing, but there's a final purchase price adjustment at closing, which uses the final actual debt amount. So that's why we've been trying to, if we were too precise now, we'd have a variance. So we were trying to use sort of rounded numbers where we expected it.
Okay.
My colleague, Mr. Canavan, just referred us to COG 29,
Okay.
which has these numbers in it.
Okay. Thank you for that.
No, thank you. So, okay, thank you. So I just want to go back a little bit. You said something very important earlier that I didn't, I think got lost a little bit in the mix, which is when utilities have debt, they never pay off the debt. They roll it over. They are always just constantly refinancing the debt. So when we think about AWA, which is actually paying off the debt, using the revenues that they have already coming through rates, because some of the costs will be cut out of the business, but other costs may come in. So they are using the existing rates. And so, but they are actually paying off that debt. That's why they're going to have the opportunity to re-optimize, because they're actually getting rid of the debt. And as they get rid of the debt, then they can use that available money instead of refinancing again through other debt. They can use that available money to pay for investment on the system so that it's lower cost. And I think in this transaction, it's just a little mystifying. Like, you almost never get this chance to do this for customers. And so I don't know if it's just a misunderstanding or if it's that it's just difficult to think of the change of the regulatory statute, of the regulatory structure. But in fact, the towns will exercise a lot of control, of course, because it's a representative and you're only dealing with costs. You're not dealing with the whole profit layer anymore, which is a point that you had brought up.
I appreciate all of that. I think what we're hearing, though, is they lack confidence in the model still.
Yes. And so they are capable, you've brought this up too, of capable of worthily representing themselves and getting themselves to the legislature and make some changes. That's, this is a statutory entity, right? This is not a law that stays in perpetuity. Like if something isn't working, it can be changed. They have all the power in the world if they want to make that change. I mean, that's, and they haven't done that, but that's clear. And to me, when I watch this, I say, they want to set it and forget it. They'd rather have Pura here. Pura is the one that has to take the heat for the rate increases instead of the towns. And it's just so much easier. And I get it that it's a difficult concept as to grasp and to think about. But if we're really going to think about customers, there is no other opportunity for customers to pay this much less. They're not going to pay more. There is not going to be a rate increase that is required to pay for this transaction. There is going to be nothing but cost benefits for them on the other side. So that's the trade-offs, which the commission already twice, everybody's talked to, the Attorney General is here saying, oh, you change your mind here, you change your mind there. But in fact, in the first decision, there was 3 prongs, 2 passed because Pura recognized, maybe not in as much detail, but Pura recognized that in the end, there's a real benefit for customers here.
But I had to learn about the statute coming in, and this was so it was part of my learning curve. And do you think? I mean, that statute has its limitations, though, too, doesn't it? As far as change of control, given the complexities of today's world.
I'm not exactly sure what you mean by that. I think that like any statute, carrying it over into practicality, can leave some emptiness, like we would like it to say more about one thing or the other. We can, and it's like civil procedure. You don't really understand it till after you get out and start standing in front of a court and doing it. And that's a little bit I think this statute, when I first read through the statute, I actually thought it actually answered a lot of questions. For instance, we heard a lot about prudence. Oh, there isn't going to be a prudence standard anymore. What is the prudence standard? Did the decision that was made, was it a reasonable decision at the time it was made, given everything that somebody knew? That is, to me, that is what that body is going to do every single day. They're going to be looking at the capital projects they have. Do these capital projects need to be done? And when you look at that statute, the statute actually has a whole section on rate making that uses a lot of the same terms that we use in our utility world.
In the change of control.
And yes, and we call it the enabling legislation.
Okay.
Yes.
Oh, okay, yeah.
Yes.
I mean, I guess, but when we think about transfers of ownership, we have this statute that says we look at, it says technological. I tend to translate that to technical, but technical, managerial, financial capacity,
Right.
which is well-known standards. It's really hard to deny that these two entities had these capabilities. They were operating now. So,
Absolutely.
why would we have any reason to believe that they wouldn't? So I'm just saying, though, it doesn't elaborate a lot, though, on the terms of a change of control or our ability to condition a change of control.
But that is going to be true for any transaction that ever comes before you. If you think about it, when Eversource came in with Aquarion, Eversource was a Connecticut utility, good at, certainly lots of people have complaints about different things, but generally good at service quality, generally professional. And here they were buying a water company, but yet, it was going to be hard to find that Eversource, even though they didn't have a water, that they couldn't handle it, right? That they couldn't be, financially or technically able. All of these transactions come down to, and this is what the consumer advocates are quite rightly looking at and arguing, they all come down to the cost impact for customers. That's what every transaction is going to come down to. Any transaction ever put in front of you is going to be about what is likely to happen to customers in terms of their cost and their service?
Yeah, so as long as I'm on the theme of the, and cut me off anytime, commissioners. But the theme of the two entities, right? These are entities of substantial scale. We wouldn't worry about them like we do with, say, very small water utilities that might struggle. It wasn't entirely clear to me, looking at the record, that there was an argument that there would be a gain in scale economies. Scale economies in water tend to come from production, and distribution actually has some diseconomies, right? Because you got to pipe that water out, and stuff weighs 8 pounds a gallon. So what do you envision, or was there anything in the record that I missed on scale advantages that might be something, say, that might be a FERC question, right? In other words, is there a scale advantage or disadvantage to a merger, or even like the loss of comparative competition between these two entities, where we could have them sort of both trying to, look like the highest or best performer in the state, right?
You're dead on. I mean, if you ask the question, what is RWA's interest in doing any of this, right? Why did they put themselves on this road? Right? That's one of the first questions I ask. They're not a profit entity, so what's the gain, right? But what they will say, and what we did say in the record, is just like you're saying, the utility business is a construction business. There's nothing but investment. Water is the only energy service that you regulate that goes in somebody's body. We don't drink or touch electricity. We don't drink or touch natural gas. We drink water. So the investment that is got to go in the ground. So if you're RWA and you've got 20 towns and you see the investment that needs to be done, well, if you can get those purchasing economies of scale in purchasing and being a bigger entity, and that's one of the things that drove, that was a factor in the Eversource merger, because the purchasing synergies can be substantial. So we did talk about that. We didn't put a number on it because it is very unique that we were able to come in and put a number on the cost savings associated with financing. And those numbers are very significant. So we did not quantify what the purchasing synergies would be. But when you start purchasing across for a broader construction base, you're going to start realizing you're going to realize for your entire base that your cost of construction can be lowered on like a per unit basis.
I'm smiling partly because I developed that point about ingesting the many years ago. And I said, you don't ingest the other utilities on purpose, that's for sure.
Not on purpose, yeah.
Not a good idea. So we talked about economies of scale. Okay, we mentioned it briefly, the challenges of new regulations and new contaminants under regulation like PFAS and meeting these requirements. So it has to be assumed that both entities will have to be making some of those capital investments you just talked about, and that will put pressure on rates. Wouldn't that occur one way or the other?
It's going to occur one way or the other. The other thing that's going to happen that I just do not understand this from a consumer advocacy point of view. If a different buyer comes in, a different buyer will be from out of state, they will be a utility buyer. And they will come in and they will invest money in the company and buying the company. They will pay some price and we'll come in and try to get approved, and you'll say, okay, fine, but you're not putting any of that acquisition premium. Don't ask me to put it in rates. You can have it on your books, but don't put it in rates. But they're going to have it on their books. And they're going to be driving the rates to cover the investment and to cover the costs that they put in buying. They will drive the rates to cover their costs, their investment costs and the costs that they've got sunk in by purchasing the company. They'd only be purchasing the company if they saw the opportunity to realize that return and that recovery. So when you think about now you have this other entity that hopefully, the processes that exist are equally investment oriented, but that is going to be the call on the towns, right? So if they want to maintain investment, then they can maintain investment or they can cut it. If they want to cut rates, they can cut investment. So, but between both companies, I think there's the reality is that the clean water going into people's, human beings, you have to do the investment. So if you have to do the investment, there's no buts about it. It's the cheaper way to go.
And you have to comply.
Right.
Yeah. So just a couple more finance questions. I'm almost done, believe it or not. So could you, since you stepped up on to talk about these issues, can you tell us anything about how the sale of, you mentioned briefly, how the sale of Aquarion would affect Eversource's risks and business profile going forward, and its cost of capital?
I mean, I'm not prepared to, I don't know the answer to that. I don't. I can see it going both ways, right? I think it was a good business and they liked it and they were hoping to make it work. So I think they are actually probably losing by selling it because they're a little bit smaller company without it, right? Every company wants to be as big as possible. Nobody wants to be losing anything that's a good, solid utility business. On the other hand, there's risks in Connecticut. Owning anything in Connecticut is a risk. So I think it can go either way, and that's probably something that in any rate case, the commission would look into. But I think it probably cuts both ways.
Okay, and this company has changed hands, Aquarion, starting as Bridgeport Hydraulic and then Aquarion and then International Investors twice, and then Eversource, and now this public authority. So it's quite the journey, isn't it?
Yes, it is. And it's, yes.
Yeah, wouldn't you argue that ownership stability?
I
is a
would
relevant
absolutely
factor?
argue that.
Okay. And then any comments on how the sale will affect from the Aquarion or the, or I should say AWA and RWA's risk profile going forward?
I'm also not I'm not a finance expert. I just play one on TV, but
Me too.
but they don't have equity anymore. So but of course you recognized earlier, there's always risk with any kind of borrowing. I think that being a statutory entity limits that risk, right? That's why you can get a better interest rate and bond rate as a public authority because you have the statute behind you. I think if anything, Aquarion is probably going into a more secure situation than where it is as part of the larger utility of Eversource that has buffered around by a lot of other forces in Connecticut and other states as well.
Appreciate that. And so one last thought, and this might be more rhetorical than actual, but would the applicants, if you could go back in time, is there anything different that you would do in terms of approaching this change of control and merger of these two entities? If you could go back in time, whether, in terms of how the whole story has played out.
That's a really good question. And always I take away from any one of these, I've done a lot of these transactions and they're always difficult because you don't like change, right? Change is hard. And like we heard today, there's so much speculation about what the future is going to be like under one model or the other. And so there's a lot of unknowns to know. I don't think we would do anything differently. I think we thought coming into this that it was so unique that you were taking an investor-owned utility to a public authority and cutting out those costs, like that it would actually be welcomed, right? By the opportunity to reach an affordability conclusion that can't be always we use in these mergers, we always use the terms, but for, like in the absence of this transaction, we could never achieve these results for customers. So I think it became very political, and that change in that letting go to the unregulated became much more than I think anybody thought.
Would that suggest that more groundwork needs to be laid before pursuing something as you say, a big change?
Yeah. I just guess I don't think so, because I don't think the towns they're not interested in like modifying it or anything. They just don't want it. They don't want the control, apparently. I mean, how else can you read it? They don't want the control. They're going to have control. They don't want the control. They're going to suffer by having to participate, not because of rates. They want to say it's rates. But they want the investment. So they're going to pay for the investment one way or the other. So it's hard to think that we could have done something better or done more upfront work if there's just going to be complete opposition to the model of letting go.
But there remains just this, as you articulated, there's this cognitive dissonance, right? And again, there is a burden on the change agent
There is.
to convince
Yeah.
those they are asking to
I agree.
change.
Which is
And-
why we tried to do the offer of compromise, and then we modified it to try to address some of the comments that came in. We've reached out continually through this whole process to the towns, to the actual town people. Then we were told, oh, we shouldn't be talking to the town. We can only talk to the lawyers. You know, we've tried hard over this time to build bridges, to meet with people. But I think it's partially a misunderstanding of the cost and how the cost is going to be covered and paid for. And I just think there's just a lot of faith and maybe a lot of faith in Pura that Pura is going to be tougher and we want to be tough. I don't feel like personally people have really looked at the process. How many times did we hear today? Oh, the OCA has approved they've approved every single rate increase. So has Pura up until 2 years ago. And those got sent back to Pura, right? Even the Aquarion one, which was a $4 million decrease, the first brief, Aquarion had to give up a couple of issues because there was math errors. And we were back up to even before we even got started on appeal. So rate increases, when you go in with a cost of service and you have done investment, there are going to be increases, whether it's utility owned or whether it's a public authority. When you do investment, there's going to be rate increases. And the fact that that OCA has signed off on every rate increase is not damning to that OCA. It shows two things. If you look at, we put some materials in the docket, the OCA is involved much earlier. They're involved much earlier in the decisions and the planning that are getting made. The principals that are involved in the decision-making. And so by the time you get to the end result, it's all been decided along the way. It's more ingrained, embedded method, as opposed to us coming in with a filing that nobody's seen until the utility brings it in, and then everybody starts there. And yeah, you don't get everything you file because guess what? You've had nobody involved in the proceeding until you walked in the door of Pura. So of course you're not going to get everything.
But it is a part-time,
No doubt about it.
one person.
I'm with you 100%.
Yeah.
There's improvements that can be done. And the court clearly said, and we gave some ideas, I think we gave some other ideas in our motion for remand, because if you see something that the judge has said, if you see things you want to change there, he's said you have set conditions, set them, right? You have the power to do that. If anybody said you don't, you do. And now the judge has confirmed that. If you want there to be more staffing, you want there to be more budget, say it.
All right, thank you very much.
Okay, thank you very much.
And don't go away.
Oh, okay.
You're not free yet. So one of the questions that I have asked is, and you mentioned, and we'll punt on the question of, whether or not the inclusion of the modified offer of compromise enforceability, ensuring that anything, whether it's a modified offer of compromise or conditions we could set with this authority out of the equation, what is the assurance, indeed guarantee, that conditions that are set will be adhered to?
So when we outlined that because that was a question that Pura asked before last September when we had our oral argument, we had three tiers. Number one, we tried to commit to a bunch of things we could do ahead of time so that you would know that they were done. Like putting the $10 million aside. Or
Ahead of time being closing the deal, even though theoretically after approval, we're gone.
You're not
Here as
gone
well.
right after approval. You're not if you set a condition that says, I want you to put that $10 million in the bank and come back to me with the bank statement before you close, right?
So the specificity of our conditions ensures continued engagement responsibility of the authority.
Because, and there's probably some examples out there if somebody researched, I'm trying to think off the top of my head if there's something in Massachusetts that would be analogous, but the way you would do it is you would say, we're approving the transaction contingent upon you putting $10 million in the bank, contingent upon you giving us the list of the pilot payments as of a certain date that you're guaranteeing to the town. So now that's on file with you. And then a corporate lawyer will come along and say, we can't close until you satisfy those conditions because the approval is contingent upon satisfying those conditions before you can close. So in our offer of compromise, we identified where there was some that you could have us do ahead of time and that your approval would be contingent upon successfully fulfilling those things. That's one tier. The second tier was, we said that some of these things, the RPB has control over, which is all Aquarion towns. And then we said, and the bottom line is you can go to Superior Court. Now, earlier, Consumer Counsel Coleman said that if we had a settlement, the settlement would ultimately go to Superior Court if somebody thought somebody wasn't living up to the settlement. So it's the same thing here. We're committing, we said in the offer of compromise, that RWA would put it into their bylaws. And by doing that, it becomes something that you can take to Superior Court if it's not fulfilled. So where did we say we put it besides the bylaws? I think we said that we would put it in the bylaws.
Okay, yeah, I actually printed off the modified offer of compromise, and I see the first part, the second part. Commitments enforceable by the AWA Representative Policy Board, commitments enforceable by other authorities.
And then I think we said they all can come back to the Superior Court. Because once they go into the bylaws, then there's a rule that says any violation of the bylaw can go to Superior Court.
Okay, thank you.
Okay.
And one final, and I'm not quite sure, looking at the Special Act 24-1, Section 53, I think subsection B, and it says the Attorney General shall have the authority to inspect any records, minutes, or financials. Do you want to weigh in on that?
I would love for RWA to weigh in on that because I'm not an expert on that law.
Good afternoon, Dan Canavan again. Did you say section 53?
It's 53, and I'm looking at, maybe I don't have, this is LCO number 6185.
Yeah, I think that language exists in the,
Was that in the original RWA agreement and it's just carried over?
one moment, please. Yeah, it's our understanding that the
That was
attorney
just-
has that right now. with
That, so it's
RWA.
carried over from the original agreement?
Correct, yes.
To your knowledge, has the Attorney General ever done anything as a result of inspecting the books, accounts, and records of the authority?
We're told no.
Has the Attorney General inspected the books, records, or
I'm told
accounts?
that he is not. Yeah, I'm told that he hasn't. The attorney
All
general
right.
has not.
Thank you.
I think we're good.
Okay, we're all set. Thank you very much.
Okay. So that brings us to the end of oral arguments tonight. So on behalf of the authority, we appreciate the arguments and discussion. Schedule currently has a final decision being voted on the regular meeting on March 25th, 2026. We are adjourned. Commissioner.
I just want to add, we've got serious weather coming in, so we want to hope everyone stays safe, and especially our utility workers.
Okay, thank you for that. We are adjourned. Have a great evening, everyone.